a criminal petition today at 2 p.m. We filed a matter on 11th. But the reason,
We have another matter. Okay.
my lord, urgency is there. My lord.
Okay.
2 p.m.
Obliged. Serve the copies to the prosecution.
May I please, Lordship? Lordship, I beg to mention hearing item 29, Lordship, on behalf of Mukam, Lordship. Lordship, if this matter may be listed after 3 weeks, Lordship, I have taken the consent of the respondent, Lordship.
You are Mr.
Lakshmi from Lordship.
Learned Counsel for the petitioner. It's praise for an adjournment of 2 weeks.
After vacation, Lordship. After vacation, Lordship.
Pardon for adjournment of the matter. Praise for adjournment of the matter with the consent of the other side, and praise for listing it after the vacation. Prayer is allowed. List after 4 weeks.
Lordship.
That will be any interim order. Is there?
Lordship, interim
order.
order.
Interim order. You should not adjourn too much. Interim order dated so and so stands extended till the next date of listing. Okay.
Lordship, I would also like to mention item number 7, Lordship, on behalf of
7.
Lordship. Lordship, the council hears some medical emergency. So if this matter may be listed after vacation, Lordship.
Learned Counsel for same
7, Lordship.
Lordship,
7.
I'm for the respondent. Let this matter be fixed after vacation on 20th July.
The learned Mr. Ahmed.
Yes, sorry.
The upper part of the same. The Mr. S. Ahmed, Learned Counsel for the respondent side. You are representing all the
1 to 7.
1 to 7, all the respondents. Does not object to the prayer for adjournment, and he also seeks posting of the matter after the vacation. List after 4 weeks will do.
Lordship, a date may fix 20th July.
Okay, no problem.
Lordship.
28 July. 28.
Obliged, Lordship.
Please, Lordship. Lordship, I would like to mention item 12.
12.
Yes, it's fixed for hearing of the IA. However, the leading counsel has some personal difficulty today. It can be fixed after the summer break. I've taken the consent of the opposite party.
You are Mr.
No, sir, on behalf of B.N. Sharma.
Okay. Learned Counsel for the applicant appel.
For respondent number 1.
Oh, you're for the respond number 1.
Lordship.
You're for the appel.
Appellant, Lordship.
No objection.
No objection, Lordship.
For the respond number 1. Makes a mention on behalf of the leading counsel, Mr.
B.N. Sharma.
B.N. Sharma, who could not appear due to some personal difficulty. And praise for listing the matter after the vacation. The learned counsel for the appellant is present and concurs with the said request. List the matter after 4 weeks. Should we fix a date or leave it to the registry?
Lordship.
If it does not get listed, make a mention.
Lordship.
Yeah, no problem. Yeah.
May I please, Lordship? Lordship, may I mention item number 15, Lordship?
1-5.
Yes, Lordship. Lordship, here I'm here to file my affidavit.
You are for the respondent.
I'm for the sole respondent.
Sole respondent.
Kindly allow me 2 weeks.
You are for the appellant.
I'm for the appellant.
Learned counsel, Mr. So learned counsel, respondent for the sole respondent, 2 weeks time to file affidavit. Full stop. The Mr. Learned counsel for the appellant side fairly submits that he has no objection. List the matter after 2 weeks.
Lordship.
Yes, ma'am.
May I please, Your Lordship? I beg to mention item 23. Lordship, I have received instruction to appear on behalf of the respondent. So if I may be granted 3 weeks time.
You are for the petitions.
3 weeks time to file my wakalatnama and affidavit.
First, learned counsel for the petitioner and full stop. Learned counsel for just appearance on behalf of the sole respondent.
Yes.
Sole respondent, and submits that they have been instructed to represent the said respondents and would be filing their wakalatnama and 2 weeks time for this. The prayers are this is the matter after 2 weeks. Any interim order?
Yes.
Interim order by so and so stands extended till the next date of list. Okay. Next.
Please, Lordship, I'd like to mention item number 16.
16,
Yes, Lordship.
16.
Lordship, let me come out of the petition to file my reply.
You're
On
for
respondent number
the,
one
you're
to
for the respondent
petition.
petition. You file a.
Yeah, I have no more questions.
Actually, it's anyway, so. Learned counsel, Mr.
No, sorry.
For the petitioner side. 6, how much time you want?
After vacation.
Submits that in the context of the affidavit in opposition filed by the respondent side, you're representing all the respondents.
Yes, 1 to 5.
And
1
all
to
the,
5.
for the respondent side, there are six respondents
I'm appearing,
and 7 respondents,
I'm appearing for 1 to 5.
only 1 to 5.
Yes.
In the context of the affidavit in opposition filed on behalf of respondent number 1 to 5, represented by learned counsel, represented today by learned counsel, so he wishes to file a reply, seek some time for the same. This is the matter after 4 weeks.
Yes, Lordship. Lordship,
Any
interim order.
Interim order 5 stands extended till the next date of listing.
Deeply obliged.
Please, Your Lordship, I beg to mention item number 5. On the consensual prayer by the councillors for the parties, can you list this matter after vacation?
You're for the petition. You're representing
Respondent number 2.
2. Format. Would you file something written? Would you file a written application?
Yes, yes.
You'll be filing. Learned counsel, Mr. So appearing for the respondent number 2. 6 an adjournment today, and also submits that he may file a written pleading.
Pleadings are completed, my lord. Pleadings are completed.
Pleading is complete, please. For full stop. It is a full stop. On behalf of the respondent, it is also submitted that the pleadings are complete. The learned counsel for the petitioner has no objection. But accordingly, this is the matter after how long?
Vacation.
After 4 weeks. Any interim order?
Lordship, there's none.
Interim order by stands extended till the next date of list.
Obliged, Lordship.
Yes,
Maybe Your Lordship, Your Lordship, I beg to mention item number 14.
1/4.
Yes, Your Lordship. Your Lordship, we have received the affidavit filed by the respondent. So I pray I may be granted 3 weeks to file a reply.
You're representing, madam, all the respondents?
I'm representing 3 and 10.
3 and 10. Okay, and the 3 and 10 have filed a
Yes, Your Lordship.
counter. Madam Additional Land Council representing respondent number 3 and 10 has filed an affidavit, and learned counsel for the petitioner submits that they may be given 3 weeks time to file a reply. Any other submission? No. Full stop. Prayer is allowed. This is the matter after 3 weeks.
Mashallah, Your Lordship.
Please, Lordship. Lordship, I beg to mention hearing item number 28, Your Lordship. Lordship, it's a,
You don't want to read today?
Your Lordship, in this matter, in IA on 18/5/2025, in IA 12 of 25, we were directed to deposit 50% of the awarded amount. We are yet to comply with that order, and I've been informed by the senior counsel that we have received the check, so I may be allowed a week's time, Your Lordship, to file.
Thereafter the hearing.
Yes, Your Lord.
First, learned counsel, Mr. appearing on behalf of the insurance company appellant, submits that it has been deposited on.
Not yet, Your Lordship. So a week time maybe.
And that process is at the final stage for deposit of the 50% of the amount in terms of the order passed by this court in a interlocutory application. First, in this context, the learned counsel seeks a week's time for the hearing. First, the learned counsel for the respondent.
Respondent number 1.
Respondent number 1 has no objection. List after a week. After a week or 10 days.
After vacation, Your Lordship.
Sure, vacation.
Is both the learned counsels further submit that perhaps the matter can be posted after the vacation as well, at least after 4 weeks then.
Much pleasure.
Mr. Lordship, Lordship, I beg to mention item 17.
1/7.
Yes, sir.
Declaration.
I pray that this matter will be listed after a week
After a week,
Yes,
you're
sir.
for the petition,
for state respondents, Lordship.
Hmm?
For state respondents.
State respondent.
Yes, sir.
Anyone for the petitioner? Have you? You'll file some pleadings?
Sorry,
Are you filing some pleading or? Would you be
Lordship,
filing some affidavit?
I'm not sure, since I'm appearing on behalf of my senior law.
Okay, no, it's okay, no, don't worry. Anyone for the petitioner?
I'll inform them, Lordship.
Inform. Learned counsel appearing for respond number, all this,
1 to 3.
1, 2, 3, the state respondents. 6, how much time would you want?
A week's time. Lordship.
Weeks time. To take further instructions and file pleading if it was. It is submitted that the petitioner side has been informed. This is the matter after a week. After a week. Kindly check if there's any interim order. Interim order, you can. ...
Much obliged, Lordship.
May I present Lordship, I beg to mention item number 9 and 10.
9 and 10.
Here, the state respondent is yet to file affidavit. I'm allowed to.
You're for the petitioner?
Lordship.
So you, state respondents, scan
file.
copy must have been, you want to file a
Affidavit,
affidavit?
by way of affidavit.
Mr. Nomi, learned public prosecutor. The government advocate is indicated as in item 10. Full stop. Submits that they may be given, the state may be given 2 weeks time to file an affidavit. Full stop. Learned counsel for the petition appears, has no objection. Full stop. This is the matter after 2 weeks.
Lordship.
After 2 weeks, interim order
Yes, Lordship.
in both the cases.
Lordship.
In both the cases,
Lordship.
interim order by so and so states stands extended till the next date of listing.
Publish.
Anything else?
Please, Lordship. Lordship, I beg to mention item number 20, Lordship.
20.
Yes. Lordship. On behalf of respondent 1, 2, and 3, Lordship.
1,
Yes,
2, and 3.
We are yet to file our affidavit in opposition in the,
For in the IA,
yes, in the IA.
for delay condemnation.
Yes.
It is. So, ma'am, you're for?
I'm for respondent number 5, honor of the bag.
Okay, fine. You're for the appellate.
Yes, Your Lordship.
Let them file then.
Yes, Your Lordship.
And the matter will be listed after revocation, Lordship.
Mr. Learned counsel appearing for,
Your Lordship, if I may, if the matter can be listed with MAC Appeal 12 of 2025, since it's an analogous case, Your Lordship.
okay, we'll do
Yes.
that. Appearing for respond number 1, 2, 3. 1, 2, and 3. They are the claimants.
Yes.
Slash claimants. Full stop. 6, an adjournment for filing an affidavit in the interlocutory application pertaining to delay condemnation
Yes, Lordship.
filed by the insurance company in this appeal. The learned counsel for the appellant has no objection. Leaves the matter when after the petition.
Yes.
Or after 4 weeks. Full stop. The learned counsel for the appellant further submits that the matter may be tagged with MSC appeal number 12 of
2025.
MSC appeal 12 of 2025. Or should we wait for the condonation of the delay or otherwise, whichever way? Then only if it is
Okay.
condoned, then it can be tagged.
Okay, Your
Okay.
Lordship.
But I will record your submission so that we remember. The council submits that at a subsequent stage after disposal of the IA in favor of the subsequent at a subsequent stage, if the IA is disposed of in favor of the appellant insurance company, then the appeal may be tagged with MSC appeal number 12 of 2020. Oh, that will take care.
Much obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 18, Your Lordship.
1/8.
Yeah, 1/8, Your Lordship.
Mhm.
Lordship, here, all the compliance affidavit have been filed and also the claimant have already appeared. So if the matter can be listed for admission hearing, Your Lordship.
It has not yet been admitted.
Because it's accommodated, Lordship.
Yes,
Links can be posted for hearing also.
yes, Your Lordship.
Okay, can you give me the file, please? I don't know whether, are you sure? You can also guide me. It is admitted, whether it is admitted. If it's not
Yes.
admitted, we can admit it and post it for hearing. The Miss Learned Counsel for the appellant insurance company, and you are representing the
For the respondent one.
and Learned Counsel for respondent number 1. Submit that the pleadings are completed and matter can be heard. What about the other respondents? They have not filed anything, right?
No.
They have appeared, have they appeared?
Lordship, I've already take a substitute notice upon the respondent, the other two respondent, and I've
They have
also
not
done
appeared.
my,
They have
yes,
not appeared.
compliance, yes.
It is submitted by the Learned Counsel for the appellant that steps of service by way of substituted service has been taken upon, in terms of order of this court,
Yes, your lordship.
has been taken upon the respondent number 2 and 3, within bracket, the remaining respondents. And compliance affidavit has also been filed.
Yes, your lordship.
And but that none has appeared so far on their behalf. The original TCR is also available. Full stop. Admit the appeal. Stop. List after 4 weeks.
Yes.
You want a specific date for preparation? That would be better, I think. You prepare and you do it. Say, you can suggest me.
July 14, Lordship.
July 14. Then you certain it will come there. Prepare. 14/7/2026 for hearing.
Lordship, similar prayer for item number 21, your lordship.
Till number 21. But 21 has IAs.
Yes, your lordship, if it can be listed for admission, your lordship.
Not today, because don't think this. There are 2 IAs
Yes,
One
one
is
is
for
for
stay.
stay, yes.
and one is for delay.
Delay. yes.
Delay condition.
Yes, yes.
Okay, first that has to be.
Yes.
signed. Okay. Oh, no, IA can be disposed of at orders also. It can be taken up at orders also. Should we do it today?
Your lordship, if it can be listed on after vacation, lordship.
Learned Counsel, you know, appear representing the appellant insurance company. With the consent of the other side. Praise for adjourning the matters today and listing after the vacation. Learned prayer is allowed. List the matter. Should we can fix a date for this as well? Same date,
Yes, your
14th?
lordship.
Same day, okay, that will be. List on 14/7.
Obliged, Lordship.
Much obliged, your lordship.
Please, your lord,
Or is-
may I beg to mention item number 7? I am
What?
for,
7,
yes, 6, item number 6.
6, 7 is mentioned already. 6.
I'm for the respondent.
Okay.
My lord, I have received the affidavit in reply just now, so we will need some time to go through it.
You're for the appellant.
Yes, lordship.
Heard Learned Counsel, so for the appellant and you're for the respondent,
Respondent,
sole respondent.
yes.
And Learned Counsel for the sole respondent. Stop. The Learned Counsel for the respondent submits that they have received the affidavit in reply. Only you received it today only.
Yes, yes.
Today
just now.
and need some time to go through it. And seek some time in this context first. The Learned Counsel for the petitioner has no objection. List after 2 weeks.
My lord, may the date be fixed on 27 July.
The submitted matter may be fixed on 27 June. List in the admission column on 27/7/2026.
Much obliged, lordship. Much obliged.
For motion, item number 1.
May I please, Lord?
Yes.
My lord, this is the as successive bail application The bail was rejected by the special judge NDPS Kohima on the ground that sections 47 and 48 have been complied, which
Have not.
according to me, which is not.
Compliant.
Yes, madam, which is not compliant. So notice may be issued and
Yes.
let it be listed on Thursday or Friday, any day.
Mr.
Eight.
Lawrence City Council appearing for the petitioner. Full stop. We'll call for the scan copy, lodged. The call for the scan copy of Kuzama PS case number 2 of 2026 under section 22C of the NDPS Act, read with section 3 within bracket 5 of BNS. He was arrested on
Five.
The petitioner was
Accused
stated
accused 2 was arrested on 5. There are 2 accused. Both of them were arrested on
accused petitioners.
5.
Accused petitioners were. There are 2 petitioners.
2 petitions. No, only one. I am for accused 2.
Okay.
Yes.
The present accused petition was filed his bail petition stated to have been arrested on 5/5/2026.
Yes.
Presently in judicial custody. List the matter on
18, madam. 18 or 19. Maju.
For motion, item number 2.
criminal petition, criminal revision.
May I please, Your Honor? Your Honor, this criminal revision petition is filed under section 438, 442, and 528. Read with section 497 and 503 of BNSS to quash and set aside the impugned order dated 01/6/2026 passed by the learned special judge NTPS and to direct the IO of the case to release the vehicle on Zima.
Jima petition.
Yes, Your Honor.
It was rejected.
It was rejected.
Issue notice and call for the.
Yes, Your Honor.
Heard Mr.
Pazar Rosa.
Learned counsel for the petition, revision petitioner, and also Mr. For the learned public prosecutor for the state. Full stop. Invoking the provisions of section 438, 442, 528 BNSS 2023. The petitioner is aggrieved by order dated 1/6/2026 passed by the learned special judge NDPS Kohima in IA 79 of 26 within bracket arising out of Kechoja PS case number 1 of 26 under then again you have to write corresponding to special case number. You just write it from here. Okay. Under so and so section. Full stop. By this impugned order, the prayer of the petitioner for release of the vehicle seized vehicle number vehicle within bracket Bolero bearing number AS03 AX1718. The prayer of the petitioner for interim custody of vehicles so and so was rejected first. Extra copies may be furnished to the prosecution if necessary. Full stop. Call for scan copy of the case record comprising relevant documents, including the impugned order from the court of the learned special judge NDPS Kohima. Give the particulars of the case, right? List the matter after
After a week, Your Lordship.
after 1 week.
For motion,
Much obliged.
item number 3.
Please, Your Lordship. Your Lordship, I beg to appear in this matter.
Appearing online.
Please, my lords. My lords, I am sorry, my lords, I am located, my lords, elsewhere. My lords, this is a petition seeking quashing of the complaint. My lords, the complaint is at page 18. The complaint is filed under section 179, that is counterfeiting, 316 and 318, that is cheating. My lords, may I kindly have para 6 of the complaint. My lords, I am a company based out of Ludhiana, Punjab. I supply and manufacture hand tools. The complainant is an authorized dealer. My lords, the allegations in the complaint are, if your lordship may have para number 5 at page 21.
Yes, I am on that. We are on the same compass.
Yes, my lords. That on 31st August 24, the complainant brother-in-law Alemba Jamir, who is standing as main witness in the present complaint, received a message so and so from accused number 2, showing that as per the accused company party had ledger complainant agency 6.84 lakhs due as on 30th of August 2024. My lords, your lordship may kindly have para number 3 for a moment. He explicitly states
Yes.
that in 2019, complainant became an authorized dealer for Messrs. Eastman Cast and Forge, that is the petitioner company, which manufactures hand tools, spinners, so and so, demolition hammers, and other hardware. Till date, the complainant's agency has ordered products, items, material worth 3.5 crores. Your lordship may kindly have para number 9 now at page 23. Now he says that he makes the orders and we supply him goods. At para 9, my lords, he says that accused number 3 handed over a party ledger showing an amount of 39,91,390. The complainant agency discussed deliberately pertaining to the outstanding payment, stating that the complainant agency had only 5.62 lakhs. Immediately the next day on 13/3/25, the complainant agency cleared the outstanding balance by making a payment of 560. On 14/7/25, the complainant agency received an email from accused number 3 demanding an outstanding of 34 lakhs 31,396. Now, your lordship may have para 14 at page 26. My lords, there is supply of goods, dues are against him. At para 14, he says that in a brazen criminal act exposing the dishonest intent of the accused around February 2020, accused number 2 acquired 2 blank checks from the complainant as security for dealership distributorship, explicitly for record security keeping purpose. On 31st October 2025, one of the complainant's check was fraudulently filled for exact false for 35,88,853 and presented for encashment. The complainant was forced to stop payment, freezed and the account under instructions of the bank manager. This constitutes an offense of forgery and using a forged document. My lord, this is the complaint that I say that you have dues to clear. I have 2 checks from him. I encash one of their checks. He stops the payment. He files this complaint. Now I filed a complaint under section 138 at the district court in Ludhiana before the magistrate, wherein summons have been issued to him and he is not appearing. While he parallelly files this complaint alleging forgery and cheating on my part for the check. In para 14, he's admittedly saying that he has filled these checks. Your lordship may have the first page of the complaint. What are the sections under which this complaint is filed? My lords, may I have para.
Mr. Kanoja,
My lords, I am Sushant Karir. Yes, my lords.
please let us issue notice, okay, and call for the records and let them appear. Then we can, proceed further. You are on bail, right? You must be on bail, right?
My lord, summoning order has been issued to me to appear before the magistrate. That is for 23rd of July. If your lordship may defer till the next date of hearing. That hearing. Because, my lords, apparently, my lords, may kindly have my complaint, page 193, my lords. Annexure P6. My lords, this is the order passed by the district court at Ludhiana under the 138 proceedings. He is not appearing.
Page number?
Page 193, my lord.
There, are you saying that on the same matter there are 2 cases?
My lords, the matter is that I have checks from him. He does not clear the payment. I encash that check. Immediately he runs to the court before the magistrate in Kohima, says that those checks have been fraudulently encashed just to cover up a defense in the 138 proceedings. And this complaint does not disclose an offense. Para 14, your lordship has read. He says that I have fraudulently encashed those checks which he himself had issued in 2020.
Let us, so, we'll take a call on your prayer for, you must be having a prayer for stay of further proceedings.
Yes, my lords, I have, my lords. I have made that prayer.
On a subsequent date, but
My lord.
next date, maybe we can give you some relief. Next date, you can appear through a council, maybe. Will that do? You can appear or
Yes, yes, my lord. My lords, local council is there, my lords, in Kohima otherwise.
that you can do that. And then in the meantime, they will appear and we'll take a call and also make effort for settlement of these kind of matters. It's
My lords, we have to recover that money, my lords.
mercantile transactions.
Yes, my lord, absolutely.
Be there, you know. It's, I guess it is compoundable, all these provisions, if it is to the extent possible. Third, Mr. Your good name, please.
Sushant Karir.
Sushant Sarin,
Karir, Kareer.
learned counsel for the petitioners, the two petitioners who has appeared through online mode from, you are appearing from
My lords, Chandigarh.
Chandigarh, full stop. Just helps, you know, to make a mention, full stop. The petitioners are aggrieved by initiation of a complaint case. Initiation of a complaint case by the respondent being complaint case number 16 of 2025, which is pending in the court of the learned CJM Kohima, and ordered, and the learned magistrate has also issued order dated 3/12/2025, summoning the petitioners in that case. At this stage, issue notice upon the respondent. Steps may be taken by speed post, expeditiously, full stop.
My lords, and through counsel before the learned magistrate also we can serve, your lordship.
That I mentioned. Stop. Call for the scan TCR of complaint case number so and so from the learning states. Any prayer for stay of proceedings shall be taken up on subsequent dates, preferably after appearance of the respondent side, full stop. However, it is submitted by the learned counsel, Mr. Green, that the next date is fixed on 26th.
23rd of July, your lordship.
23rd July for the learned court at Kohima. Full stop. On the same day, the petitioners are given the liberty to appear through learned counsels. Okay.
Grateful, your lordship.
The petitioners and the respondents are also at liberty to make efforts for settlement of the matter to the extent permissible by law.
My lord.
After 4 weeks.
My lord.
After 4 weeks, 5 weeks, something like that. So,
My lord, any date convenient to your lordship.
even after a particular date. List after 4 weeks. Okay.
My lord will give a returnable date, your lordship.
You can, I can give a date also. You can suggest.
That will be
30 July, 30 July.
grateful, my lords.
37.
Grateful, your lordship.
For motion, item number 4.
Yes.
May it please your lordship. Your lordship, here the petitioner is praying for washing the complaint case, which is
Complaint
pending.
case.
Yes, lordship, which is pending before the Chief Judicial Magistrate Kifri. Lordship, annexure 1, that is page 21. That is the complaint petition, lordship.
Annexure 1, page
Page 21, lordship.
21.
Yes.
21.
Yes, lordship.
So,
That is the complaint petition filed by the respondent one. Lordship, here, the facts of the case is that during the year 1973, 5 site permit was issued by the Tubashi, which is in my para close to, lordship. Para 1, lordship. Now, during the year 1973, they
page? Para 2 of the complaint.
yes, no, lordship, para 5 clause 1 of the criminal petition, lordship.
Petition.
Yes, my petition, lordship.
Clause 5.
Yes, lordship.
that mention may be made. It starts like this.
Yes, Lordship.
You want to read it? Page 40, para 5.
Yes, Lordship.
Okay.
Yes, Lordship, during the year 1973, the Dubashi had issued some site permit for the construction of commercial building.
Long-standing background.
Yes, Lordship. Thereafter, the petitioner great-grandfather had also made a representation before the concerned authority, that is it, page 123, Annexure 3 series. As the site permit was issued with
What page?
123, Lordship.
23.
Yes, Lordship. Also follow up by the petitioner 1, Lordship, that is at page 124.
Will issue know what is the stage of the complaint case? What is the stage of the complaint case? It is at what stage?
Yes, Lordship.
No, stage of the complaint case. I mean, it is trial is going on.
No, Lordship. Not yet started, Lordship.
Not yet started.
Yes, they've summoned on 23 of this month.
23 of this month. Would
Yes.
you like to appear on that? We'll
No,
call
Lord.
for the records. You appear, you get a bill. Yeah. Or you appear through counsel.
Okay, true.
Like last.
Okay.
Similar offer. Heard Mr. for the learned counsel for the petition. And SK learned early prosecutor for respond number 2. Actually, is the state necessary?
It's just a formal part.
Formal party.
Yes.
Who submits that the state would be a formal party in this proceeding, which is arisen of a complaint case. The petitioner, the three petitioners herein have invoked the provisions of Act 528 BNSS, seeking quashing of complaint case number 1 of 2026 under so and so section. The complaint case was initiated on the basis of complaint dated. What is the date of the complaint? Help me with the dates. Complaint dated.
Lordship, in order was passed on.
Complaint dated ... filed by the respond number 2. Respond number 1. You're 2, right, madam?
Yes, respondent.
Yes, for respondent number 2.
With certain allegations. Whereupon the complaint case was registered and the learned complaint was registered and the learned magistrate was pleased. The learned magistrate filed order dated
23rd April 2026.
25/4/2026 was pleased to summon the petitioners as accused. It is submitted that the next date for the appearance is fixed on
23rd
23rd July.
June, Lordship. 23rd June, Lordship.
Copy may be furnished, extra copy if necessary may be furnished to the prosecution. Steps of notice by speed post
Okay.
shall be taken upon the complainant / respond number 1. Call for the scanned TCR of complaint case number so and so from the learned court bill. On the next date, that is 23/7/2020, 23/7.
Yes.
23/7/2026. The
Lordship, 23/6/7.
23/6.
Yes.
23/6/2000. The petitioners as accused are given the liberty to appear through learned counsels. That also you can add the petitioners, the petitioner, the petitioners and the complainant are at liberty to make efforts for settlement of the matter to the extent permissible by law. This is necessary now. This wherever it is possible.
Lordship, I've got to pray for interim, Lordship.
Interim will be for the stay of proceedings.
Yes.
That will be considered. The prayer for stay of further proceedings shall be considered subsequently, preferably after appearance of the respondent side. On the next date, you can actually you could have appeared and gone on bail.
Okay.
But next date you appear through learned counsel.
Okay.
And then maybe on the next date. List
But-
after any specific date you want.
Lordship, after 3 weeks, Lordship.
After 3 weeks, I think it will fall in the middle of the Will it fall in the middle of the,
After the vacation, Lordship.
After the
after 4 weeks?
Right.
After 4 weeks.
Much
For admission, item number 8.
May I please, my lord? My lord, this is a contempt petition, my lord.
Yes.
My lord, may kindly peruse the affidavit filed by the respondent number 2.
Just a moment. Just. You are appearing for?
May I please your lordship? Lordship, I'm making a mention on behalf of principal counsel, who is the arguing counsel in this case, my lords. Since the arguing counsel is in court one, having a fixed matter. However, my lord, so far the matter here is concerned, one writ appeal in connection to this has been filed. However, the same has been remained effective. So in connection to this.
You are representing your seniors.
Your lordship, there was positive direction from this court
Okay.
for the
No,
counsel
sir,
to
you are
appeal.
representing which respondents?
For all the respondents.
All respondents.
All
No
the
problem. All the 5 respondents. 1 to 5. Okay. Now which affidavit I should see?
Affidavit filed by the respondent.
The grievances with regard to what kind of order, direction for? Let us see that order, lordship, since I am dealing with it for the first time.
Lordship, the gist of the case, lordship, before the record.
Yeah, you can say.
Lordship, the petitioners were newly recruited as a constable GD in CRPF.
Mhm.
So after few months of the recruitment, they were dismissed from the service for the reason that there were mismatch of domicile district. There was mismatch.
They challenge that.
Yes, then they have approached this Honorable High Court, and this Honorable High Court was pleased to set aside the dismissal order and directed the respondents to induct back the petitioner
Reinstate.
to lordship
Reinstate.
forthwith to reinstate forthwith.
Mhm.
Until now, they have not done it. And in this contempt petition, the respondent number 2 has relied on certain SLPs that are pending before the Honorable Supreme Court. So they are waiting for that.
Okay.
But those SLPs have already been dismissed by the Honorable Supreme Court
According to your feedback.
in the month of September,
Last year.
lordship. And I've received the affidavit in the month of December.
Okay.
Lordship, I have the order.
The judgment and order is dated 21/5.
Lordship, 2024.
You're saying, Mr. Counsel, that the writ appeal has been filed against this order.
Yes.
This specific order. Yes. But SLP, it must have
SLP was different issues, same subject, but was filed different.
different issue. No,
Different case from different states.
No, the order dated 21/5/2024 is the order.
Lordship, they have taken the ground that similar case is pending before the Honorable Supreme Court.
Similar case.
They have stated in paragraph number 2 by respondent number 2.
Anyway,
But all the SLP
have been
has been
dismissed.
dismissed.
So there are contrary contentions, it seems. Anyway, so let me have a look.
And respondent number 3 and 4, 5 has stated that it is the respondent number 2 who should comply with the order. But respondent 3 and 5, they are the appointing authorities. And respondent number 2 is the staff selection commission. Their recruitment body.
The para 18 is relevant, no? You're at page 22 of your contempt petition. Impugn orders dated so and so are set aside. In that
Lordship,
forthwith.
18, yes.
inducted back in Fort Wayne.
Fort Wayne,
This was in 2024.
24, 25.
See, the thing is that in any competition, one of the most important things that whether the order is attained finality. So there's some dispute over that. It seems was any writ appeal filed by the state against this order?
They have filed. There was also delay. Delay was condoned, but however, they have filed without annexing the pleadings. They have filed by annexing.
See, the thing is that whether 21-5 order has attained finality,
Lordship,
in other words, whether writ appeal was filed.
it was filed, but it was found defect.
If it is filed, what happened thereafter? Whether any
It has final
Supreme Court
attend. It has attained finality, Lordship, but they have filed a writ appeal. Delay was condoned, and writ appeal was found to be defect, and they were directed
to correct it
to cure that defect.
Okay.
But till now, they have not done it. It's more than they were directed in the month of February, Lordship.
My lord, we have already attended. However, as I read in the last occasion.
the writ appeal has been admitted.
Yes.
No, Lordship.
No, my lord, we have already filed, but it appears that some of the annexures, it
I
claims.
think let us adjust this matter a little bit because his senior may be necessary.
Lordship.
During this.
For some time.
After some time, he's busy there. No?
Yes.
We'll hear after some time.
Right.
And then we'll take a call. What can be done about this? According to you, this SLPs are all dismissed.
Dismissed, Lordship, which they have relied by respondent number 2.
And at the outset, you mentioned about one affidavit.
Lordship, that was filed by respondent number 2.
Let me see that. Respondent number 2. Okay. Affidavit dated 12 December 25.
I have received on 10, 12. That will be, Lordship.
No, this respondent number 2 affidavit dated 12 December 25.
Lordship.
This one.
Lordship. Page 4, Lordship.
Yeah.
Para 1, Lordship. Lordship has got it.
Mm.
Before adverting to the Para-wise reply, the deponent craves the leave of this honorable court to bring into the light the facts and circumstances in order to express his inability to in not complying with the judgment and order dated such and such passed by this honorable high court. And the Para 2, these are the SLP they have relied on. Because of this, they have expressed their inability to comply with the order passed by this honorable high court. However, Lordship, all these SLPs are dismissed.
Various SLPs. Where can we?
And next paragraph is the
WA number, what is the, do you have the writ appeal number?
Yes, my lord. WA 28 of 25.
28 of 2025. That is pending before this court.
Yes.
Before the division bench of our court.
Lordship, technically it's not pending because they have not cured the defect.
From our side, we have attended, man. From our side, we have attended.
Because if the defect is not cured, it will be liable to be dismissed.
Lordship.
Anyway, let us get after.
Lordship.
I got an idea of this.
Lordship.
Obliged.
For admission, item number 11.
Yes.
EPS to start the
Yeah.
case, the GR case.
You would be appearing for the private response. Yes, sir. Public prosecutor, should we start? You can just make the initial address, then you can. I can do that. Can you? Stop there, no? Later on. But you want me to release this? Start again.
I don't have to recapitulate if your lordship.
No, no, not necessarily.
Yes.
You can just
I
reply.
have to rebut,
Ah,
I have
you
to,
just-
I have to
just
rebut
reply.
them.
Just reply.
Once they complete, I have to rebut them.
Basically, the crux of the submissions, land senior counsel submissions, is that in none of the transactions the name of the person figures, and he's the only thing is that he's been named in FI.
That's
So he has been roped in unfairly, illegally, and therefore should be quashed with regard to it. And also the coexistence of 409 is 420 is essay.
I'll just address
No
one
address.
issue,
Yes.
not
No
at that, at this time. I'll address because your lordship's fallen from your lordship was that what is the effect of a vicarious liability? That your lordship has fallen, I have noted down.
Vicarious liability, no, I'm saying that it is it is a fact that in the transactions and the connected documents,
Yes.
his name is not there,
Yes.
right? And the only thing is that his name is in the FIR and 120, there's one allegation in the presence of so and so he was given. One vicarious liability in the sense that whether the informant or the complainant is
Yes.
trying to see, he's probably trying to say that this gentleman is also involved in conspiring.
Yes, ma'am.
Because admittedly,
No, what they said,
he has not.
no, my lord, what they have taken different. In their objection, they are saying the company in the name of the account. So I will show it, my lord,
Okay.
how it has been dealt.
We
by
can
this.
sit a little bit and then you can come.
My lord,
That will be better. That's not a problem. Flexible. Yes. Master.
Also, I would like to place the case diary logic.
Yes, diary. Okay.
Logic.
It's come now today. The scanned or original?
It's a scheme.
Okay.
Logic, starting from the first page logic. The statement of the complainant logic.
Mhm.
Third paragraph. If I'm allowed to read.
Yes, go ahead.
On record statement of the complainant Kohima, son of so and so, resident of so and so, Dimapur, Nagaland. Under section 161 CRPC, on examination, the complainant stated that he is a businessman and a politician. In the year 2004 and 2005, he became acquainted with Mr. Pradeep Agrawal, son of so and so, through mutual friend as they were both engaged in business in the year 2010. Mr. Pradeep Agrawal informed him about a business proposition in real estate at Kolkata, which could yield good profits. On 10/12/2010, at so and so, Dimapur, Nagaland, he was introduced by Mr. Pradeep Agrawal to Mr. Arun Bathoria, who represents himself as one of the director of MS Apcon Properties Private Limited, having its office so and so, Kolkata. Arun Bathoria proposed that if he invests in the company for a period of 3 to 4 years, the company will yield return investment amount with 30% profit. Though initially skeptical, on assurance of Mr. Pradeep Agrawal and Mr. Arun Bathoria about the company's financial soundness, he agreed to invest. Accordingly, on 10/12/2010, he handed over 1 crore in cash at so and so Tiger Village. Thereafter, on 17/12/2010, at the office of Apcon Property Private Limited, he handed over rupees 4 crores in cash to Mr. Arun Bathoria in the presence of Mr. Pradeep Agrawal and other directors. More importantly, other directors of the company, namely, number 1, Anil Bathoria, secondly, 2, Milan Shah, and third, Sandeep Bathoria, Lordship. Lordship may kindly.
Yeah.
So the name of Mr. The present accused petitioner is number 2, Milan A. Shah, Lordship. He is also one of the director, Lordship. Lordship may kindly come to page 6, Lordship, of the CD, dated 25/8/2025.
P6.
Logic. If I am allowed to start from the paragraph, third paragraph, logic. The statement recorded.
Or Pradeep Agarwal.
Logic. If I am allowed to continue. Now recorded the statement of Mr. Pradeep Agrawal, age 55 years, son of late so and so, New Delhi, under section 180 BNSS. On examination, he stated that his father was a businessman and his mother a housewife. He is the youngest among 7 siblings. He completed his Bachelor of Commerce from Bhawanpur College, Kolkata. By profession, he is engaged in the real estate business and has been associated with MS Abcom property for the past 35 years. He maintains good family relation with Sri Arun Batoria, Sri Anil Batoria, and Sri Sandeep Batoria. He has known Sri Kohoi Sema for the past 20 years. Having first met him in the Dimapur during a business trip, through common friends, over time, they developed a close friendship and extended financial support to each other when required. In 2010, Sri Pradeep Agrawal visited Dimapur along with Sri Arun Batoria to meet Sri Kohoi, as Sri Arun Batoria was seeking financial assistance for a real estate project in Kolkata with promised return of 30% profit of investment. The investment amount was fixed at 5 crores. On so and so, the complaint provided 1 crores in cash, which was carried by train to Kolkata. Subsequently, Sri Kohoi personally delivered the balance of 4 crores in cash to Sri Arun Batoria in Kolkata in the presence of 3 other directors and Sri Pradeep Agrawal. On the same day, a money receipt was executed on which Sri Pradeep Agrawal signed as a witness. In 2015, when he approached Sri Anil for repayment of the investment along with profit, he was informed that the liability could not be settled immediately due to the demise of Sri Arun Batoria. In 2016, very important, Lordship, 2016, the 3 directors assured him that a project has been sanctioned and will be completed by 2020 and 2021. As an assurance, they handed over the sanctioned project plan to him. In the mid-2022, he once again requested the directors to clear the dues since the said project had already been completed. However, they made repeated excuses, and by December 2022, it became clear that the directors had no intention of repaying the investment along with profits. Accordingly, he informed Sri Kohoi and advised him to initiate legal proceeding in January 2023. Upon lodging on an FIR by so-and-so in Dimapur, Sri Pradeep Agrawal informed the 3 directors of the same. They requested him to persuade Sri so-and-so to grant them additional time. Acting in good faith, he conveyed their request to Sri Kohoi, who agreed to extend the time as sought by them. However, despite repeated reminder, no payment has been made to date, and the directors continue to give false assurance. He further clarified that he had introduced Sri Kohoi to company and acted as a negotiator between Sri Kohoi and the company. At no point of time did he receive any or take any money from the investment of Sri Kohoi Lodge. Pradeep Agrawal was again so and so. This now the police under section, the last 2 paragraph, Lordship. First, police notice under section 35 BNSS was served on so and so, Lordship. Now, one is Anil Batoria and the second is Milan Shah, basing on the statement of Pradeep Agrawal, Lordship. Lordship, I will only go into the relevant paragraph, Lordship, of the CD. Lordship,
Right.
may kindly come to page 45, Lordship. Page 45. Page 45, dated 3/1/2026, Lordship. The relevant paragraph, page 46, Lordship. Page 46. I will read only the operating part. The second paragraph, starting from now self-received, Lordship. Lordship has got
Page 45.
46.
Or 46.
I will only read the relevant paragraph so as to
Now self.
now self-received. Now self-received, the goal
Actually,
became
these anything other than the statements we should not read out completely
logic.
because these are slightly confidential. I can read it myself. Shall we receive call details? Okay.
Lordship, the page 47 is also relevant. Why? Because 9 directors of the company notice was served on 9 directors. Page 47. And Lordship may kindly come to page 50, Lordship. Dated 28/1/2026, Lordship.
Page 50.
Very important. This is the statement of the accused, Lordship. The present accused, Milan Shah, through DC. Now, there is important, Lordship.
You can read this one.
Logic. If I may. Now self-recorded, the statement of accused Milan Shah through VC on examination, he stated that he was introduced to Arun Botoria and Anil Botoria by a broker, namely Jay Chajar. Approximately 25 years ago, he further stated that he had been investing in the companies owned by Anil Botoria and Arun Botoria and Anil Botoria. He categorically stated that he has never met the complainant or Pradeep Agrawal. He further stated that on 24/11/2010, he was inducted as a director of Epcon Property Private Limited. He stated that he had never visited the office of the Register of Companies of Epcon Properties Private Limited situated at Park Street, Kolkata, and that he had not recollected who had advised or requested him to become a director of the same company. He further added that he joined the company as a professional director at a time when the company was investing in properties at Behal. The accused categorically stated that he was only an investor and was not involved in the day-to-day affairs of the management of the Epcon Property Private Limited. Why I'm reading this, Lordship? The statement as well as is contradicting, Lordship. Why? Because he has been inducted as a director in the year 2010, and that is also important. 24/11/2010. Now, the transaction was done in the year 1 crore. The transaction was done on 10/12/2010. Relevant page 2.
Okay.
And 4 crores transaction was done on 17/12/2010. At the time, at that relevant point of time, Lordship, when this transaction was done, Lordship, he was the director, he was inducted as a director of Epcom. One loss. Lordship, may kindly come to the relevant page 56, Lordship. Dated 19/2/2026, Lordship.
Statement of
Statement of J.
Chajar. Yeah, read.
Lordship. On examination, Sri J. Chajar stated that he is a real estate broker by profession and has been engaged in property dealing for several decades. He deposed that he has known led Arun Botoria and Sri Anil Botoria since the year 1991, having been introduced to them through his father, who was also involved in real estate brokerage and has had professionally association with the Botoria family. Over the years, he maintained continuous professional interaction with them in connection with various property transactions and described his relationship with the family as a long-standing and close, almost akin to the family ties. He further stated that he came into contact with Sri Milan Shah through Rajesh Biswal approximately 20 to 25 years ago and has since maintained business relation with him. He stated that he has participated in around 3 to 4 property transactions with Sri Milan Shah, whereas his dealing with Botoria family were more frequent. Lordship, from the statement, Lordship, it appears that the dealings with the Botoria family by the Sri Milan Shah is more frequent, Lordship. Very important, Lordship. More frequent and regular in nature in his capacity as a brokerage agent, Lordship. he stated that in the course of his experience in property dealing, it was common practice for a transaction to involve both accounted check, bank transfer, and unaccounted cash component between buyers and sellers, particularly in the high value real estate transactions. Very important, Lordship. With regard to the property situated at Behal, Kolkata, he stated that during the period 2009 and 2010, he identified and proposed the same property to Sri Milan Shah as well as to let Arun Batoria and Sri Anil Batoria for the purpose of purchase and development. He further stated that he personally accompanied Sri Milan Shah, led Arun Batoria, Sri Anil Batoria, and Sri Sandeep Batoria to the site for inspection and verification of the property project. Lordship, so from the statement of J. Chajar, Lordship, it appears that the person accused, Sri Milan Shah, is more frequent with the Batoria's family, Lordship. And Lordship may kindly come to page 60, Lordship. CD. Dated 25 to 2026. Now, accordingly, notice under Section 94 of BNSS were issued and duly served upon the companies on multiple occasions on 28/11/2025, 8/12/2025, 3/1/2026, and 18/2/2026, directing them to produce the requisite documents. Despite repeated service of notices and grant of adequate opportunities, the companies failed to furnish the complete set of documents as required for the investigation project. This is dated 25 to 2026 project. In spite of Section 94 of the BNSS Lordship and duty served on the company's Lordship, in spite of that Lordship, they failed to submit the complete set of documents Lordship. And Lordship may kindly come to page 62, Lordship, which is also very important, Lordship. This is dated 1/3/2026, Lordship. Okay. Lordship. Now this is the documents, Lordship. Now self-received report of 3 companies: Zenith Nirman Private Limited, Abinhood Vinma Private Limited, Distri Tower Private Limited. The company has provided with all the documents related to notice served under Section 91 and 94 BNSS. Now, the complainant appeared and produced certain relevant documents pertaining to the property situated at Behal, Kolkata. On examination of the said documents, it was revealed that the property in question was being dealt with under the name and style of MS Gestram Estate. Further scrutiny of the documents disclosed that the power of attorney has been executed in favor of Sri Milan Shah. Now, very important, Lordship. Now, the power of attorney has been executed in the name of Sri Milan Shah, authorizing him to act on behalf of the said entity in the matters relating to the property. Subsequently, Sri Milan Shah was examined in the connection with the case. During his examination, he stated that he was not involved in the day-to-day activities of the company and claimed to have only a limited or nominal role. However, on careful perusal of the documents produced by the complainant, particularly the power of attorney and other related records, it appears that Sri Milan Shah was entrusted with substantial authority and was effectively in overall charge of affairs relating to the said property. And coming to the last paragraph, this inconsistency raised doubt regarding the veracity of his statement and suggests possibility concealment of the material facts. Lordship, in the earlier, during his statement, Lordship, he has stated that he has, Lordship. And Lordship may also come to page 63, Lordship. This is dated 3/3/2026, Lordship. Now received documents were received from MS Epcon Properties Private Limited in compliance with the notices issued earlier. The documents so received were taken on record and examined in detail. On scrutiny, it was observed that the company had furnished only partial records. Very important logic, including certain documents and bank statement limited to a period of approximately 2 years. The remaining reports are requisitioned have not been provided, which appear to be incomplete and insufficient for the purpose of comprehensive investigation. Further examination of documents revealed that the property situated at Bihal, Kolkata was built under the name and style of MS Kesram Estate Lodging. Now only the partial records were received, Lordship. And Lordship may kindly come to page 72, Lordship. This is dated 2/4/2026, Lord. Lordship, if I'm allowed to read, Lord.
Page?
Page 72 of the circuit law, dated 2/4/2026.
Towards the end of the sitting.
Lordship, end of Lordship, if I'm allowed to read, starting from the second paragraph. During the course of investigation, it has been established from the documentary evidence that the property in question was being dealt with under the name and style of MS Kestram Estate. A power of attorney was executed in favor of Sri Milan Shah, authorizing him to act on behalf of the said entity in matters relating to the property. Statements recorded during investigation further reveal that Sri Milan Shah was introduced to late Arun Batoria and Sri Anil Batoria by Sri J. Chajar. It has also come on record as per the statement of Sri J. Chajar that in earlier 2011, Sri Milan Shah had indicated that an amount of rupees 5 crore has been arranged from an investor based in Nagaland towards the said transaction. Further, it is revealed that 6 companies were shown as co-owners of the said property in the year 2012. Records also indicate that the building plan forming part of the conveyance deed and deed of declaration was prepared and or submitted before the Kolkata Municipal Corporation by Sri Haris Sanon, an architect by profession. Now, important logic. Sri Milan Shah, during his examination, stated that he was not involved in day-to-day affairs of the company and had only a limited role. However, the power of attorney and related documents clearly indicate that he was vested with substantial authority, suggesting his active involvement in the management and execution of matters relating to the property. This creates a direct contradiction between his oral statement and the documentary evidence on record. Very important, Lordship. Further contradiction arises in the timeline of transaction, wherein co-ownership of the property is shown to have been transferred to 6 companies in 2012, whereas the alleged advance consideration was paid only in 2016. This discrepancy raises serious doubt regarding the genuineness and sequence of the transaction. It has been observed that Sri Haris Sanon prepared and or submitted the building plan without physically measuring the plot of land, thereby raising serious concern regarding the accuracy and authenticity of the plan submitted before the Kolkata Municipal Corporation. Now, very important, Lordship. Additional certain crucial documents pertaining to Epcon Properties Private Limited, which are necessary to establish the legitimacy and chronological sequence of the transaction, have been reported missing only in the year 2024. The selective absence of such vital documents at a later stage appears suspicious and indicate possible suppression of or manipulation of records. The reliance on virtual mode, now Lordship, the reliance on virtual mode for recording statements in a case involving complex transaction dating back to 2010 has also emerged as a procedural limitation, as effective confrontation of witnesses with documentary evidence and cross-examination could not be adequately conducted. The above facts, contradictions, and lapses collectively indicate prima facie irregularities in the transaction possible concealment of material facts by key persons involved, and deficiencies in documentation. This aspect warrants further detailed investigation, including custodial or physical examination of the concerned individuals and throughout verification of financial transaction and report. Lordship, therefore, Lordship, their physical presence is required, Lordship. And in fact, the through virtual mode, it will become difficult to no.
That's all.
Lawful.
Mr. Ajima.
Firstly, my lord, may I take your lordship just to one paragraph in the petition. One paragraph. At page 4, paragraph 3 of the petition filed by them. Paragraph 3 of book. Yes, madam. Just to point out, my lord, that the MO of the petitioner continues even before his honorable court. Paragraph 3. What does he claim to be his status? Paragraph 2. May I read, my lord? That the petitioner respectfully states that the petitioner is a businessman by profession, engaged in the business of providing consulting service to IT and logistic firms through their firm Ansell Services Private Limited, registered under the Companies Act of 2013. The petitioner is one of the directors of the above mentioned. Now, why am I mentioning this, my lord? Is this so-called Ansell Services is not involved in this transaction, but the petitioner seeks to portray that this is the extent of his business and he is not involved in any other company. Now, the records will show, my lord, that this petitioner is involved in multiple companies, and that, in the first instance, is a deliberate suppression of fact. And for that reason alone, this petition should be thrown out, my lord, if I may humbly submit.
Yeah.
Why not? Like last time, but bullet points plus, man. Make it easy. For ease of reference now. And I'll take it, lordship, straight to the bullet points. First paragraph, my lord. The petitioner prays for quashing the FIR dated 11/10/2025.
So I am entitled to get one copy. Please submit me.
Just bullet points.
No, whatever.
I'll give you a copy.
Please give me a copy so that I also know what is.
I can give you a copy. You can make your submission form.
Yes, very good.
Okay.
The petitioner prays for quashing the FIR dated 11/10/25, registered in the suburban police station, Dimapur, by suburban case number such under sections 409, 420, 120B of the IPC. FIR dated 11/10/25, annexure 1, page 27 to the petition. You can go straight to the FIR, my lord. Page 27 to the petition. Page 27 is the formal record of the FIR received. The actual FIR now, my lord, is at page 29.
Page 29
of the petition. Of the petition.
Yeah.
Page 27 is the formal.
What is the corner?
Yes. And the actual FIR is page 29.
Right.
May I read, my lord? I take this opportunity to lodge this complaint against the following persons who have hatched a criminal conspiracy amongst themselves, and in furtherance of such conspiracy, they have cheated me the sum of ₹5 crores, thereby causing wrongful loss to me and wrongful gain to themselves. The accused persons are Anil Batoria, Milan A. Shah, and Sandeep Batoria. All three accused persons are mentioned, my lord. And your lordship will also recall the other two persons have also filed similar petitions like this, and those have been listed for a different date. The aforesaid accused persons are the owners, controllers of a company named MS Upcroft Properties Private Limited, having a place of business at such and such. On 10/12/2010, Arun Batoria, now deceased, was introduced to me by Shri Pradeep Agarwal, son of such and such, who has been known to me for many years. The meeting was held at Hayakka Village, Dimapur, which is under the jurisdiction of your police station.
Arun Bhadoria, deceased, represented to me, which representation subsequently transpired to be false and dishonest, that their business was in very good financial health, but that he required a long-term cash accommodation in the form of a loan in goodwill and promised to pay me a profit of 30% of the loan amount. At the relevant time, he manifestly suppressed the true financial health of his companies and sought a long-term loan of rupees 5 crores only for a period of 4 years. Relying upon such assurance, I, the undersigned, handed over a sum of rupees 10 crores only in cash on the same day, and I agreed to give a further sum of rupees 4 crores on 17/12/2010. Now, the point is this, my lord. If your lordship will see in the first part of paragraph page 30, they wanted the investment in cash. Obvious reasons, my lord. They did not wish to leave a money trail. They wanted the investment in cash. Then, subsequently, in furtherance of my earlier assurance, on 10/12/2010, a sum of rupees 4 crores cash was given on 17/12/2010 by me to Shri Arun Bhadoria in his office at 105 Park Street, Kolkata, in the presence of Pradeep Agarwal and 3 other directors of Apcon Properties Private Limited, namely accused numbers 1, 2, and 3. All the 3 accused are specifically named, my lord. All the 3 are specifically named. And what are the ingredients of an offense? My lord, is it necessary that I pin down each and every ingredient specifically in the FIR? It is not necessary. Then, in or around September 2015, I requested the accused to account for and return the sum of rupees 5 crores along with profit, and also immediately sought the intervention of Shri Pradeep Agarwal. After weeks of persuasion and requests, the accused person sought time to clear their liability, citing reasons that the father of accused number 1 had recently expired and they thus requested for some time. In and around December 2016, I again requested the accused persons to return the loan to me along with the profit, and once again sought the intervention of Shri Pradeep Agarwal. The accused persons collectively assured me that the company project had been sanctioned and that by 2020-2021, the project would be completed. Further, all dues would be cleared. After that, a copy of the sanction plan is the next hearing. Now, the sanction plan was given by them to me through Mr. Pradeep Agarwal. That is the import of this FIR matter. It was given by them to me, the remaining 2 directors.
It was given by
the remaining 2 directors, Anil Bhadoria, Sandeep Bhadoria, and Milanesha, through Mr. Pradeep Agarwal. In mid-2022, I once again approached the accused persons for repayment of the loan amount along with profit. The accused persons kept delaying the matter with one excuse or another, and by December 2022, it became apparent to me that the accused persons have no intention of repaying the sums due to me. I am aware that these accused persons have defrauded many other persons in this manner. They are a threat to society and commerce. A thorough investigation is thus required to unearth the nature and extent of the criminal conspiracy hatched by them. I am a private citizen and I have no resources to gather the necessary evidence to prosecute the accused persons. Meanwhile, the interrogation is promptly required to quash the modus operandi of the illegal activity. The false and dishonest inducements were made at Hackett Village, Dimapur, Nagaland, which is situated under the area of your police station, and therefore I request you to kindly treat this as a first information report and investigate the offense. Now, my lord, this FIR is corroborated by the statement of one of the witnesses, which was read out just now before your lordship in the case diary, on Mr. J. Chadar. He said that sometime in 2010, 2011, the petitioner himself told him that they had received a cash investment of rupees 5 crores from the state of Nagaland. Now, your lordship, if you can go back to the bullet points. The second point, yes, bullet points. The paragraph which I alluded to earlier, my lord, the petitioner states that he is a businessman and director in a firm in the name and style of Ansett Services Private Limited. The petitioner states that he is innocent in relation to the FIR dated 11/10/2025, that he has been implicated purely to harassment. And in fact, your lordship, it is not 11/10/2025, it is the 2023 affidavit, 2023 FIR. The petitioner states that he has never met the respondent number 2 and that he was appointed only on 24/11/2010 as a director of MS Apcon Properties Private Limited for a specific project, and after the project was over, the petitioner resigned from the said company on 22/6/2023. The lordship will find this in paragraph 6 of the petition. The lordship may kindly note the date. This date is very important. The 2 dates, my lord. First, he says he was appointed only on 24/11/2010,
Okay.
which Your Lordship has already noted.
Ah.
And then the statement, the subsequent statement, that he was director of Apcon Properties Private Limited for a specific project, which is Shutter project, if I may say so, my lord. And after the project was over, the petitioner resigned from the said company on 22/6/2023 because the project was completed in the year 2023, my lord. And this is in paragraph 6 of the petition. No need to go through that, my lord. I've mentioned the paragraph. Next paragraph. The petitioner states that while he was abroad visiting his daughter on 6/9/2025, he learned of the filing of the FIR and the arrest of Mr. Anil Bhutoria and Mr. Sandeep Bhutoria, two of the other persons named in the FIR. This is in paragraph 7 of the petition. He states that since he was abroad, he was not able to appear before the IO of the case on 31/10/25, and that he never received any notice under section 35(3) of the BNSS. This is also paragraph 8 to the petition. My note, my lord, the asterisk is my note. The petitioner reveals full knowledge of the investigation by the IO of the case and the orders passed. This may be seen from paragraphs 8, 9, 10, and 12 of the petition. For someone who claims to be abroad, the statements in these paragraphs show that he has complete information, even the minute details of the case. And Your Lordship will see that in paragraphs 8, 9, 10, and 12. And 6. The petition also states that a dispute between the family of late Mr. Arun Bhutoria and Mr. Pradeep Agarwal is linked to the FIR filed by the respondent number 2. He alleges that the FIR has been filed at the behest of Mr. Pradeep Agarwal. This is paragraph 10 of the petition. 7. The petitioner states that the case of the respondent number 2 is based solely on the monthly receipt dated 17/12/2010. Can we pause here for a moment, my lord? And in my written objection, I have a clearer copy of this receipt at page 33 of my written objection. I have a clearer copy.
That's page 33.
Yes, my lord. Page 33. This is the 33 is the handwritten note. May I read from this, my lord?
Okay, no, I'll go through it. No,
And Your Lordship will see at the bottom, it is for Apcon Properties Private Limited.
Okay.
For Apcon Properties Private Limited. And this is at a time when the petitioner was already a director, 17/12/2010. Now, the petitioner says that he was not present. He was not present when this receipt was given to the complainant. And the reason for that is this receipt does not bear his signature. That's the only simple reason. And that is a reason which deserves to be rejected at threshold. Receipts are not signed by multiple persons or multiple directors. One person alone is sufficient to sign a receipt. But most importantly, Your Lordship will note, for Apcon Properties Private Limited. Okay. Then the petitioner states that the case of the respondent number 2 is based on the money receipt dated 17/12/2010 issued by late Mr. Arun Bhutoria. He states that the said receipt was issued in private capacity. Wrong, my lord. It was not issued in the private capacity. It was signed for Apcon Properties Private Limited of late Mr. Arun Bhutoria, and his signature is not reflected. The first transaction took place on 10/12/2010, and the second transaction took place on 17/12/2010, whereas late Mr. Arun Bhutoria had resigned from Apcon Properties Private Limited on 24/11/2010, and he was not even a director when the transactions took place. He also alleges that the receipt is forged. Paragraph 11 to the petition. Now, again, if I may pause here again for a moment now. If Mr. Arun Bhutoria was not a director on 17/12/2010,
right,
the deception started there. The deception started there. When he signed as a director executing on behalf of Apcon Properties Private Limited. And it is my case that the money was handed over to Arun Bhutoria, Mr. Anil Bhutoria, Mr. Sandeep Bhutoria, and Mr. Milan Shah in their office, in the offices of MS Apcon Properties Private Limited at Kolkata. Now they say that they were not there. Not only him, not only this petitioner, but the other two petitioners. They say that they were never present when the money was handed over. Now that, Your Lordship, that is evidence which can only be unearthed during the course of investigation.
Okay. Okay, go on.
Paragraph 8 now. The petitioner states that the FIR dated 10/10/2025 is a figment of imagination of the respondent number 2, as no such transaction ever happened. All this, my lord. Paragraph 8 has ever happened, and that he has never met the respondent number 2. That it is unlikely for any person to invest the amount of rupees 5 crores on a handwritten money receipt, and that more than 15 years having lapsed, the allegations in the FIR dated 11/10/25 are doubtful. 9. The petitioner states that the FIR does not disclose the ingredients of offences under sections 409, 420, and 120B of the IPC, followed by a lengthy exposition in relation to this amendment, and your lordship will find that in paragraphs 14 to 18. And 10. The petitioner states that no prima facie case has been made out for the offences alleged, and therefore the FIR dated 11/10/25 is liable to be quashed with the petitioner. The additional affidavit of the petitioner, executed on 4/3/2026. The additional affidavit was filed by the petitioner's brother. In this additional affidavit, the petitioner questioned the notice of the IO of the 3 companies. Observed these 3 companies. He alleges that the IO is undertaking a roving inquiry in relation to the aforesaid petitioner's companies. Kindly note, my lord, the aforesaid petitioner's companies. In the writ petition, he says he's the director of only one company. In his additional affidavit, he brings it to light that he has 3 other companies, and that the police is conducting a roving inquiry in respect of those 3 companies. He states that the notices issued to these companies are solely for harassing him, and that these companies have no connection or relevance to the transactions alleged in the FIR dated 11/10/2025. Another false statement, man. And your lordship will find that in paragraph 12 to the additional affidavit. My written objection, however, the respondent number 2 and Mr. Pradeep Agarwal are known to each other. They collaborate in businesses. Mr. Pradeep Agarwal also acts as a respondent number 2's financial investment consultant. In the year 2010, Epcot Properties Private Limited, through Mr. Arun Bhatoria, contacted Mr. Pradeep Agarwal and requested him to look for investors for a project they were about to take up. Mr. Pradeep Agarwal had previous business transactions with Mr. Arun Bhatoria and his brother, Mr. Anil Bhatoria. Their specific requirement was investment in cash. The Bhatoria's brothers told him about the construction project they were going to undertake in Kolkata. They informed him that they had already begun negotiations for the purchase of 2 plots at Bihala. This is the project, my lord, Kolkata, for the project, and that the same terms had been agreed upon for the purchase of this. And the terms had been agreed upon for the purchase of the same. 3. Mr. Pradeep Agarwal contacted the respondent number 2 and sounded him out about the project. The respondent number 2 agreed to meet with the representatives of Epcot Properties Private Limited. As such, on 9/12/2010, Mr. Arun Bhatoria and Mr. Pradeep Agarwal reached Dimapur by train from Kolkata. The same evening, they met with the respondent number 2 at his residence. Mr. Arun Bhatoria presented the respondent number 2 with an overview of the project with the estimated costs and returns. He told the respondent number 2 that they had identified 2 plots of land at Bihala, Kolkata, on which a multi-story building would be constructed. This is the project now. He also told the respondent number 2 that the sale considerations for the 2 plots of land had been agreed upon, and once the sale was concluded, the execution of the project would not be problematic. 4. Convinced by the feasibility of the project as presented by Mr. Arun Bhatoria, representative of Epcot Properties Private Limited, the respondent number 2 agreed to invest the sum of ₹5 crores in cash. Accordingly, on the next day, he handed over to Mr. Arun Bhatoria the sum of ₹1 crore in cash in the presence of Mr. Pradeep Agarwal. Mr. Arun Bhatoria then invited the petitioner to visit the office of MS Epcot Properties Private Limited to meet with the other directors and finalize the deal. 5. On 17/12/2010, the respondent number 2, along with Mr. Pradeep Agarwal, visited the registered office of Epcot Properties Private Limited, located at 105 Park Street, Kolkata. In this meeting, the respondent number 2 interacted with Mr. Arun Bhatoria, Mr. Anil Bhatoria, Mr. Sandeep Bhatoria, and Mr. Milan Aisha. All of them held themselves out to be directors of MS Epcot Properties Private Limited. In their interactions, they assured the respondent number 2 that his investment in the project would be profitable and without risk. Based on their assurances, the respondent number 2 handed over the amount of rupees 4 crores to them. In their presence, Mr. Arun Bhattacharya signed the receipt dated 17/12/2010 in his letter pad as the director of MS Epcon Properties Private Limited. The receipt is Annex 1, page 33 of the written objection. The receipt clearly shows that Mr. Arun Bhattacharya signed for MS Epcon Properties Private Limited as a director acting for and on its behalf. 6. The assurances of the directors of Epcon Properties Private Limited, including the petitioner herein, in relation to the project, induced the respondent number 2 to hand over the sum of rupees 5 crores to them in cash. In fact, it is the said directors themselves who wanted the investment in cash. The reasons, therefore, need no exposition. 7. Mr. Pradeep Agarwal was a witness to the transaction with Epcon Properties Private Limited, represented by its aforementioned directors. In relation to the project, he is the representative of the respondent number 2. 8. Through Mr. Pradeep Agarwal, the respondent number 2 was subsequently informed that a sale of the 2 plots aforementioned had been concluded and that the plots were registered in the name of MS Epcon Properties Private Limited and 8 other companies. Rashid will come to that. But this was the information supplied to me by them. 9. The investment of the respondent number 2 became due since no information in this regard was supplied to him by MS Epcon Properties Private Limited. In September 2015, through Mr. Pradeep Agarwal, he contacted MS Epcon Properties Private Limited. It was only then that he came to know that Mr. Arun Bhattacharya had expired on 8/10/2011. The other directors, namely Anil Bhattacharya, Sandeep Bhattacharya, and Milan A. Shah, assured Mr. Pradeep Agarwal that they would repay the respondent number 2's investments. Also, since Mr. Anil Bhattacharya's father had recently expired, he requested some time. Having learned of the bereavement aforementioned, the respondent number 2 did not press for an immediate resolution of his affairs with Epcon Properties Private Limited. When he followed up in 2016 through Mr. Pradeep Agarwal, the other 3 directors, Anil Bhattacharya, Sandeep Bhattacharya, and Milan A. Shah, informed him that the project had been sanctioned by Kolkata Municipal Council and the construction of the same would be completed by 2020-2021, whereupon they would repay the respondent number 2's investment. They handed over a copy of the sanction order of the project approved by the Kolkata Municipal Council to Mr. Pradeep Agarwal, and issue 2, page 35 to 47, is of my written objection now. It is a big page, so I've broken up into pieces and then find it like this. Then, paragraph 11. The end of 2019 and the beginning of 2020 saw the COVID-19 pandemic take hold worldwide. After the easing of the lockdown restrictions sometime in the last part of 2021, through Mr. Pradeep Agarwal, MS Epcon Properties Private Limited was again contacted. The petitioner and the other 2 directors gave further assurances that the investment of the respondent number 2 would be returned when the project is complete. These meetings took place in the offices of MS Epcon Properties Private Limited and also in other places in Kolkata. Now, why am I saying other places in Kolkata? As has been noted in the case study, these people are known to each other and keep on meeting in many places. 11, 12. The project was completed and a completion certificate dated 28/4/2023 was issued. Kindly note the date, madam. 28/4/2023. And the certificate is Annex 3, page 48 to the written objection. 28/4/2023. And we will relate this to the date where he said that he resigned from the company, which your Worship has noted earlier. In the petition relies on a document at page 55, where at serial number 18, it is shown that Mr. Arun Bhattacharya ceased to be a director of MS Epcon Properties Private Limited with effect from 24/11/2010. Your Worship has already seen that. The full form 32 was actually filed only on 21/12/2020. Now, in my written objection, Your Worship, at page 49 to 53.
I take up the written objection.
Yes, madam.
Page
49 to 53.
Which complete distance? Yeah.
Your Worship.
49.
No, page 49, 51.
51. 49 to 53.
49 to 53, madam.
Perfect. These are
Yes, madam. I'll take your Worship to the relevant page. I have marked it.
filings under the Companies Act.
Yes, madam, under the Companies Act. And at page 53. Page 53. At the bottom of the page, E-form filing date, Your Worship will see.
21/12/2010. 21/12/2010.
Yes. And he says that he resigned on 25/11/2010.
Okay.
But the actual e-filing date is 21/12/2010. So the point I'm trying to make, Your Lordship, is the deception began from the very beginning. And by their very own statements, they say that Arun Buttoria was not a director when the receipt dated 17/12/2010 was executed. Take a short minute. Very good.
5 minutes. Within 5 minutes.
Further reference as far as this paragraph is concerned, my lord, Your Lordship will see in the petition file, the petition has enclosed only the page which shows his date of resignation. They have not enclosed the full form. That is also again a suppression of facts, my lord.
Where?
In the petition, my lord.
In the petition.
Yes, ma'am. In the petition.
The petition at page.
Page 55.
55.
The relevant part is at 56. The last entry.
Yes, page 55. Yes, 56. 55 and 56.
Last entry.
The last entry is 24/11/2010. So they have not enclosed the full form.
Okay, next.
Paragraph 14. Upon receipt of the notice of dissenting petition, respondent number 2 was able to obtain documents from the official.
You're reading page?
Paragraph 14, page 8 of my notes.
Compilation.
of my notes.
Okay, I'm on that, there only.
Yes.
Page 14 only.
Paragraph 14.
Yes, I'm there.
Upon receipt
Receipt
of
of
the
the notice.
Upon receipt of the notice of this instant petition, the respondent number 2 was able to obtain documents from the official records. These documents show that a well-orchestrated plan was put into effect by Mr. Arun Bhattacharya, Mr. Anil Bhattacharya, Mr. Sandeep Bhattacharya, and Mr. Milan A. Shah to defraud, cheat the respondent number 2 of the amount of rupees 5 crores. The modus operandi adopted is stated hereunder. They required a huge amount, a huge investment. They wanted it in cash so as to not leave a money trail. They approached Mr. Pradeep Agarwal and requested him to look for investors, whereupon the respondent number 2 was contacted. At Dimapur and Kolkata, Mr. Arun Bhattacharya and the other directors convinced the respondent number 2 to invest in the project and give them the sum of rupees 5 crores. For reasons which need no telling, they wanted the investment in cash, and the receipt was executed by Arun Bhattacharya for MS Epcon Properties Private Limited. Trusting them, the respondent number 2 accepted their proposal and they handed over the sum of rupees 5 crores and took the money receipt dated 17/12/2010, which was given to him by them. The 2 plots on which the project was to be executed were purchased in the name of MS Epcon Properties Private Limited and 8 other companies. The 3 companies to whom the notices were issued, as mentioned in the additional affidavit, are part of this group. D. The aforesaid 9 companies formed an association of persons in the name and style of Shetram Estate. These facts are reflected in the power of attorney dated 25/4/2017, Annexure 5, page 54 to the written objection. Can we go to that in Asia Minor, page 54? Page 54 of my written objection. Before. Yes, my lord, 54. May I read the recitals, my lord? It's important to read the recitals. These are relevant. And this is a power of attorney dated 25th day of April 2018. 1. Epcon Properties Private Limited, a company incorporated under such, having PAN number such. 2. Swadeshi Apartments Private Limited, all the 9 companies. What? And then page 56, my lord. All the 9 companies are mentioned. 57, page 58, then, my lord. Of the one part, can your lordship come to that in the middle of the page 58? Of the one part, in favor of Shetram Estate, an association of persons formed and constituted an agreement dated 24/1/2016, having PAN number such, having its principal place of business as such, represented through its authorized signatories, Mr. Milan A. Shah. Kindly note the name, my lord, the petitioner, son of Mr. Shantilal Shah, and Mr. Shivam Milan Shah, his son. Next page, my lord. Gitanjali Billing, etc., etc. Then whereas the above said owners have, by way of indenture of conveyance, have peacefully occupied, possessed under themselves the plot of land measuring all that piece and parcel of land measuring 48 kotas, etc., etc., and being numbered as such within the local territorial limits of Kolkata, etc., etc. And whereas the above said owners have, by way of another indenture of conveyance, have peacefully occupied, possessed under themselves the plot of land, etc., etc. Then, and whereas next page 60, my lord. And whereas we are seized and possessed and are otherwise well and sufficiently entitled to all that piece and parcel of land, etc., etc. And whereas we have caused a plan being building permit number such duly sanctioned by the Kolkata Municipal Corporation for construction of a basement ground plus 9-story building at the said premises hereinafter referred to as the new building. And whereas we intend to nominate, constitute, and appoint the said Shetram Estate to be our true and lawful attorney to act and to perform the following things. So in this Shetram Estate, the power of attorney now is the petitioner and his son. It's the petitioner and his son. Can we come back to the notes again, Mama? Continue with the notes. This document shows that the petitioner, Mr. Milan A. Shah, is the authorized signatory of all the 9 companies.
Which para? 14?
Yes, Mama.
14, which
D.
14D?
Yeah. 14D.
E.
Yes.
As the representative of,
yes,
starts like this.
14D, the aforesaid 9 companies were no in the notes.
Yeah, I'm on the notes on
The aforesaid 9 companies,
14 page.
page 9. 14D at the bottom of the page, yes.
Mhm.
The aforesaid 9 companies formed an association of persons in the name and style of Shetram Estate. These facts are reflected in the bar as dated 25/4/2018 in HS and such petition. This document shows that the petitioner, Mr. Milan Asia, is the authorized signatory of all the 9 companies. He is also the authorized signatory of all the 9 companies mentioned in the power of attorney. He and his son are also the authorized signatories of Shetram Estate. By this power of attorney, Shetram Estate was appointed to execute the project. The 9 companies are mentioned in paragraph 2Q, pages 9 to 10 to the written objection. As the representative of respondent number 2, Mr. Pradeep Agarwal had frequent meetings with Mr. Anil Bhutoria before his passing. Mr. Anil Bhutoria, Mr. Sandeep Bhutoria, and Mr. Milan Asia on his visits to Kolkata. In all these meetings, he kept on assuring him that as and when the project is completed, the investment of the respondent number 2 would be returned. Mr. Pradeep Agarwal himself, on his visits to Kolkata, personally inspected the progress of the project. From 2020-2021, the COVID-19 pandemic set in and a lockdown was imposed. Towards the end of 2021, on the instructions of the respondent number 2, Mr. Pradeep Agarwal visited Kolkata and met with Mr. Anil Bhutoria, Mr. Sandeep Bhutoria, and Mr. Milan Asia singly and jointly on different occasions. He assured him that the project was near completion and the respondent number 2's investment would soon be returned. In the year 2022, on further visits to Kolkata, they kept on giving him the same assurances. However, their reluctance began showing and he appeared disinclined to return the investment of the respondent number 2. This information was conveyed to the respondent number 2. On being informed of the conduct of the directors of Apcon Properties Private Limited, the respondent number 2 filed an FIR dated 7/1/2023. So this is the actual FIR and not the 25 which the petitioners mentioned. Whereupon Mr. Pradeep Agarwal informed them of the same. They requested Mr. Pradeep Agarwal to intercede, stating that the project was completed and they would return the respondent number 2's investment. On their request, the respondent number 2 kept the FIR filed by him on hold. However, the assurances to return the respondent number 2's investment did not materialize. It was on their request that I kept the FIR on hold. Consequently, the respondent number 2 filed a supplementary FIR dated 18/8/2025. This is the Annex 9, pages 128 and 129 to the objection. The filing of the FIR and the petitioner resigned from Apcon Properties, this is the court, my lord, Private Limited on 22/6/2023 is not a coincidence. And why? I will show that, my lord. It is not a coincidence. He stresses on this resignation in paragraph 6 of the petition. However, he has concealed the fact that he is a continuing director in the other companies which form the association of persons for executing the project. He and his sons are the authorized signatories of the said association of persons. He is also the authorized signatory of MS Apcon Properties Private Limited. He still is, my lord. He says he has resigned, but he still is. In relation to the execution of the project, an FIR dated 21/12/2024 has been filed, and in this case, the petitioner, Apcon Properties Private Limited, and other companies which form the association of persons are also implicated. Now, this is a fight between themselves now. The petitioner in paragraph 7 states that he was in the United States when notices in the case were issued. However, from the information supplied, the respondent number 2 has learned that the petitioner was in fact in Kolkata from 18/11/2025 to 24/11/2025. Paragraph 9 to the written objection. This fact can be ascertained from entry and exit points, my lord, if one is going abroad, and this is also a subject matter of investigation. And it is a false statement to say that he was in the USA all this time. He states in paragraph 7 of the petition that he was in the United States of America on 6/9/2025, and as such, he said from then on he was in the United States. He did not receive any notice, and that the order dated 19/11/25 was issued when he was not present in the country. And this is paragraph 8 of the written petition. The project was completed on 28/4/2023. From the public records, the respondent number 2 was able to obtain the sale deeds of 4 units sold in the years 2021, 2022, 2023, and 2025. Lordship. Page 139 to 194 to written objection. In the sale deed dated 7/10/2021, the petitioner is an executant representing both MS Apcon Properties Private Limited and Shetram Estate. In the sale deed dated 28/9/2022, pages 150 to 167 to written objection, the petitioner is an executant representing both the Apcon Properties Private Limited as well as Shetram Estate. In sale deed dated 12/5/2023, the The petitioner is an executant representing both Apcon Properties Private Limited as well as Shetram Estate. In the sale deed dated, this sale deed is important by now. In the sale deed dated 18/3/2025, the petitioner is an executant representing both Apcon Properties Private Limited as well as Shetram Estate. Can I take your lordship to this last sale deed, my lord? Page 186 of my written objection. And your lordship will keep the date 22/6/2023 in mind. His statement in his petition saying that he resigned as a director of Apcon Properties with effect from this date. 186. Your lordship got? This is for sale of one of the units in the project. Your lordship will see the seal and signature at the bottom of the page. Apcon Properties Private Limited, Director Milan K. Shah. Has the lordship got it? At the bottom of the page. Apcon Properties Private Limited, Director Milan A. Shah, constituted attorney of all these 9 companies. All these 9 companies. And in the last page, you should see again. At page 193. His signature again at page 183. And in page 186, your lordship will also see he has signed on behalf of Shetram Estate also as member at the bottom of the page, at page 186. Bottom, at the bottom. And you also got to see Shetram Estate, the seal Shetram Estate, and signature. So, my lord, coming back to page 13 of my notes. In the middle of the first paragraph, the relevant point of note is that in paragraph 6 of the petition, the petitioner claims that he resigned as director of Apcon Properties Private Limited on 22/6/2023. However, the sale deed dated 18/3/25 clearly shows that he executed the sale deed on behalf of Apcon Properties Private Limited as its director. He was/is still maintaining this connection with the said company. And in response to my written objection, an affidavit in reply was filed. Can we go to that, my lord? D1. The petitioner states that the transaction is purely a commercial one and that the money receipt was in a letter pad of Mr. Arun Bhattacharya in his personal capacity. Not true, my lord. The records amply demonstrate that. Further, that Mr. Arun Bhattacharya was not even a director of MS Apcon Properties Private Limited when the money receipt was executed. Wrong statement, my lord. He became a director by his own statement with effect from 24/11/2010. Receipt is 17/12/2010. As he had already resigned when the money is no, this is with regard to Arun Bhattacharya. The statement that Arun Bhattacharya was not a director as on 24/11/2010. And he could not have signed as the director of Properties Private. Whereupon the petitioner was inducted as the director. Also, the money receipt does not bear the signature of the petitioner. The same argument run. The next page, page 14. The petitioner is an investor in Apcon Properties Private Limited, and he was inducted as a director on 24/11/2010 and resigned on 22/6/2023. He keeps on harping on this date, my lord, that he resigned on 22/6/2023. It is not a solitary statement, my lord. It is a statement which is repeated again and again and again. 3. The petitioner had never heard of or encountered the respondent number 2 prior to the instant FIR. Now, therefore, my lord, as far as this statement of the petitioner is concerned, I say that I met him. He says he never met me. How are we to prove that, my lord? Only an investigation will unearth the facts. Not before. Okay. Then the number 4, the petitioner is not involved or aware of the alleged transaction with the respondent number 2 or Mr. Arun Bhattacharya. He states that the claim was that he was present when the transaction took place on 17/12/2010 is belied because the money received does not bear estimate. Same thing, my lord, same argument again. 5, the petitioner states that to attract the offense of cheating, there must be deception and dishonest intention at a time of making the inducement whereby a person fraudulently or dishonestly induces another to deliver any property. Fully met, my lord. Fully met. Abcon Properties, acting through their directors, induced me to invest 5 crores. Now they are saying that the person who signed on behalf of Abcon Properties was not even a director. And to substantiate that, they put forward a date which they placed before this honorable court. But they did not enclose a full document, which shows that the actual document was filed much after. The petitioner states that the FIR dated 11/10/2025 does not contain any ingredients to attack the provisions of sections 409, 420, 120B. My lord, what I have stated in the written objection and the FIR itself, it is in the firstly, my lord, the FIR itself is not required to mention each and every ingredient of the offences. And what I have stated in my written objection and the documents which I have placed on record will amply show, your lordship, that offences have been committed. Now, what offences have been committed, my lord? The investigation will reveal. Just because certain sections are mentioned in the FIR, does it mean the trial proceeds on that basis only, my lord? It does not. The police themselves can change the sections on the which an accused is charged. Charge can be framed under these sections, but the trial court itself can change the sections on the basis of the evidence led. And to say that the argument has been marked by the other side, that 409 and 420 do not go together. I agree, that is a settled principle of law. But does it mean that just because these offences don't go together, an FIR cannot be registered under these sections? No, man. Does it mean that just because these sections are mentioned together, that a charge cannot be framed under these sections? No, my lord. That is not a valid proposition in law. Yeah. Can we continue, my lord? Page 15, the notes now.
Page 15.
Page 15, yes, ma'am. The respondent number 2 has not produced any evidence to establish that Mr. Arun Bhattacharya was acting on behalf of MS Abcon Properties. This, on the face of it, is an argument which needs to be rejected, my lord. The receipt was given to me, signed by Arun Bhattacharya for and on behalf of Abcon Properties Private Limited, in their presence. The petitioner states that the association of persons has no relevance to the case. In fact, your lordship, in the affidavit in reply, a very casual approach has been taken as far as my written objection is concerned. It's as if they exist in different worlds altogether. And what I have stated in my written objection has no relevance as far as the FIR is concerned. That is an absolutely misconceived proposition. 9, the petitioner states that his statements in paragraphs 5.1 to 5.15 of the written objection have no relevance to this case. Lightly brushing aside my written objection altogether, my lord. The petitioner states that the sale of units in the project have no relevance to the case. Same thing, my lord. Nothing. It is just what the petitioner says in his arguments which I have placed, my lord. E arguments. The petitioner has never met with the respondent number 1. He was not present on 17/12/2010 when the transactions took place. The project executed by Shetram Estate has no relevance to the instant case. He resigned as director of MS Abcon Properties Private Limited on 22/6/2023, and he has no connection with the said company. The case, if any, is of a civil nature. There is no case against him. This is in fact his case. To sum it up, respondent number 2. What is my case? The FIR dated 7/1/2023 mentions the name of the petitioner and 2 others as those responsible for defrauding/cheating him of rupees 5 crores. MS Abcon Properties Private Limited is specifically named. The FIR also specifically states that on 17/12/2010, the money was handed over to the petitioner and 2 others who held themselves out to be directors of MS Abcon Properties Private Limited in their office at 105 Park Street, Kolkata. The petitioner states that the association of persons Shetram Estate has no relevance to the instant case. However, MS Abcon Properties Private Limited, through its directors, the petitioner and 2 other accused themselves, handed over the sanction order of the project with the assurance of returning his investment. 3, the petitioner claims that he resigned from MS Abcon Properties Private Limited on 22/6/2023. However, the sale deed dated 12/2/2025 shows that he was still representing Abcon Properties Private Limited as its director on the date of its execution. The petitioner has indulged in false and concealed and suppressed material facts. In relation to the same project, an FIR has also been filed in Kolkata. The respondent number 2 invested money in Epcot Properties Private Limited. The sum of rupees 5 crores was accepted by the petitioner and the other co-accused. They assured the respondent number 2 that as and when the project is complete, his investment would be returned. The project was completed in 2023. However, the petitioner and the other co-accused have not kept their promise. They have not kept their promise, and now they are saying that there was no such transaction as far as they are concerned. So whether there was actually such a transaction or not, now your lordship is no more of a civil nature. Is there any genuineness in my allegation that they accepted 5 crores, which they are denying now? That only an investigation will allow us and establish the truth. They now feign ignorance regarding the respondent number 2's investment, notwithstanding the denial of the petitioner. Taken at face value, there is a prima facie case against the petitioner and the other co-accused. As such, the investigation into the FIR will bring out the truth. Hence, the petition is liable to be rejected. 7. Since the petitioner has deliberately made false statements, suppressed and concealed facts, the petitioner is liable to be dismissed with exemplary cause. He is also liable to surrender before the eye of the case. This are my notes, my lord, and I will just place 3 authorities before your lordship. Then I will conclude my submissions. The first is 2024 INSC 233. And this is by a 3-judge bench of the Honorable Supreme Court. INSC Supreme Court. Yeah, the C 2024 INSC. We have more. We have more. Oh, para? Your Lordship, paragraph 3 contain the facts. And this is also about investment, my lord. And investment which was not.
Para 3 only?
Yes, 3. No, 3 also, my lord. And then paragraph 9 onwards, my lord.
9 onwards.
Yes.
I have shown that also. Your lordship will find it.
And
I have
at
also.
paragraph 11, at page 11, at page 10, your lordship, the grounds on which a 482 petition will lie, an old case has been referred to, my lord. And paragraph at page 11, Roman 5 at the bottom of the page. Your lordship,
Page 11.
Page 11, man. Yes. Roman 5 at the bottom of the page. A given set of facts may make out A, purely a civil wrong, or B, purely a criminal offense, or C, civil wrong as well as a criminal offense. The commercial transaction or contractual dispute, apart from furnishing a cause of action for seeking remedy in civil law, may also involve a criminal offense. As the nature and scope of a civil proceeding are different from a criminal proceeding, the mere fact that a complaint relates to a commercial transaction or a breach of a contract for which a civil remedy is available or has been available is not by itself a ground to quash the criminal proceeding. This will just respond I wish to rely on. So, no, this point now. So in this case, there were other accused also, but the appellant who was not, there was nothing against him. Against him, the complaint was Washington. Not so in our case, man. Not so in our case. Then, just for guidance, my lord, there are 2 decisions of the hearing. One is of the Delhi High Court and one is of the Allahabad High Court.
This is the Delhi High Court decision.
Yes, my lord, Delhi High Court decision. On the point of your lordship, after the Delhi race course case, where the Honorable Supreme Court says that section 406 and 420 are mutually exclusive because they can't be together.
Delhi race course, we have shown.
You have shown this?
Yeah, Delhi race course.
Delhi race course has been dealt with here. This case.
Yes, I think this is High Court.
Yeah. Yes.
Next. Another one, Allahabad High Court also.
Allahabad High Court also.
As you wish, if you want to show.
Lordship, the Delhi racecourse case is dealt with by the Honorable Delhi High Court, and Lordship will see at page 46.
A person cannot be convicted for both
Yes.
the offences together.
Yes. And here, in this case, charge was framed and that was questioned.
No, charge will be valid if it is alternative charge, but not together.
Even charge, no, what the Delhi High Court says, even charges can be framed together, but under 221 of the old CRPC and 224
Alternative
PNSS,
charge is better.
can be altered. So this is the decision just for guidance, my lord. And your lordship will find that in page 54. Page 54,
Fine.
paragraph 25. Is the lordship heard? Paragraph 25
Of the Delhi
High Court, yes.
Paragraph 25.
Yes. So we are not in our case, we're not even talking about the framing of charges, my lord. This is at the investigation stage, just
Yeah.
the FIR. But in this case, even the framing of charge under this section was upheld, saying that in accordance with the provisions of law, depending on the evidence led, the charge can be altered. And there is no infirmity if charge is framed under both sections. Paragraph 25. The previous paragraphs are the discussion, my lord, and this is the decision. In view of the aforesaid discussion, and in fact and circumstances of the present case, the impure order framing charges, it is 1978-22, passed by Learner CGM, insofar as it relates to framing of charges against the petitioners for offences punishable under 409-420, read in section 120B of the IPC is upheld. Even for framing of charges, it's possible. Later on, based on the evidence led, I can be convicted under different sections. And this was followed, this Delhi High Court case was followed by the Allahabad High Court lordship, and your lordship can see that in paragraph 18 of the Allahabad High Court. Last page. Paragraph 18. There's a reference to the Delhi High Court case. In the middle of the page, your lordship, recently in another case of Pim Sen Arora versus State, Delhi High Court case. The previous case which I was referring to. So therefore, my lord, just because one of the sections may not lie. Just because one of the sections may not lie, there is no reason in law to propose that the FI should be washed. So I am alleging, my lord, they are denying. The only course now is for an investigation into the allegation and the denial, and the truth to be unearthed. And at this stage, my lord, my humble submission is that no case has been made out for invoking the jurisdiction of this noble court under section 428. And now, I keep forgetting the section number, my lord. The new section.
Yeah, that's
528.
problem.
Yes, madam.
Yeah. Oh, that's BNS is still better. I more problems with BNS. All the subsections.
So that is my case, madam.
I'll just give a reply, my lord. The reply first to the whatever the advancement of argument by PP, my lord.
Yes.
First.
Yes.
My lord, there is certain things which has been not been told by my learned friend PP. He mixed up the case, my case along with Bhatoria's family, with Anil and Sandeep Bhatoria. Accused number 1 and 3. I will show some orders of this court where it will be clarified that what was the order that was passed by this court and whether we complied with the order passed by the court or not. That's very important, my lord. What was the order that passed by this court? Please look into first order of 10/12/2025. I'm troubling with your lordship with some orders because I have to clarify because my learned friend PP has said there is no compliance of 35, there is no compliance of 94. I'll show how I complied. Here, the Bhatorias has not complied. And in fact, is mixing the case with Mr. Bhatoria's family. Please try to look at the order of this court on 10/12/2025.
10/12.
10/12. Please see that.
Just one. Okay.
Now, my lord will kindly leave the facts. Your lordship is aware of the facts. Please see 5, paragraph 5. Facts all narrated after 13 years. Please see para 4, my lord. 1 para 4. I'll trouble to para 4, my lord. Para 4. Para 4. Learner Senior Counsel further submitted that in year 2023, after 13 years, a GD entry was made it, but it was kept in abeyance as some assurance was given from the accused person, and subsequently, FIR had been registered only in year 2025. I'll pause for a moment. My learned friend for the informant said that is the actual FIR is a GD entry. With greatest respect, my lord, GD entry cannot be an FIR. Now, in his objection, written objection, he said supplementary FIR. There cannot be a supplementary FIR, my lord. There can be an FIR, but it was registered only in 2025. There was a GD entry. Mr. Das, the learned senior submitted. These are all oral submission from the informant, but there is no documentary evidence except the money receipt to substantiate the plea of the complainant. A transaction was completed in presence of the petitioner, who is one of the directors of the company, namely EPCON. Now, please see 5. Further, it is submitted as per one notice under section 35(3) BNSS was stated to be issued on 14/10/2025, directing the present petitioner to appear before the IO on 31/10/2025. But the present petitioner was never received the notice under section 35(3) BNSS and is presently in the US. After the miscarriage of his daughter, and since August 2025, he is in the US. But without even receiving the notice and order of issuance of non-bailable warrant of arrest was produced by the IO, and subsequently by order dated 2/12/2025, learned magistrate has withdrawn that NBW which was issued earlier against the present petition. Further, citing the judgment of Honorable Supreme Court, so and so, there is no ingredient to attract so and so, so and so. Now, my lord, the narrated, but the instant case is seen that is a purely a commercial transaction where the informant assured 30% profit by so and so, so and so. There cannot be any case so and so. Now, please see 6. However, it is submitted by Mr. Das that present petitioner is still ready to cooperate with the IO in compliance with section 35(3) BNSS, and he has made be interrogated virtually and is presently staying in US. Mr. Das further submitted no coercive action may be taken against so and so. Learned PP, Nagaland submitted case is still under investigation, and his presence is required, for which notice under section 35(3) BNS has already been issued against the petitioner. But despite of the notice issued to the petitioner, he is not cooperating with the IO, and hence his physical presence may be required for the interest of the investigation. Considering the entire submission made by learned counsel, perusing the case record along with the annexures and the petition, IO is directed not to take any coercive action against the petitioner. However, the accused petitioner is directed to extend his cooperation with the IO of this case. However, till his return from US, he may be interrogated and his statement may be recorded by IO through virtual mode. However, the IO will also make inquiry in compliance with section 35(3) of BNSS after his physical presence, IO preferably within the first week of February. Issue notice so and so, so and so. So that was the first. Now, please see. There is an IA which has been filed by before this court, 2 of 2026. Please see the order of 29/1/2026. Please see the order of 29/1/2026.
29/1.
29/1. Now, please see. My learned friend has said that there is no cooperation. My friend PP was also appearing in that case when I moved all these IAs. Please see. Because I have to clarify myself that he said there is no cooperation, still investigation is required.
Locating the order.
29/1/2026. IA criminal 2 of 2026. IA.
It's not here.
There is an extra copy also.
Okay. No problem.
Yes, please see that, my lord. Paragraph 2. The learned senior counsel for the appellant submits that the applicant, in terms of this court's order dated 10/12/2025 and 19/1/2026, has fully cooperated with the IO, and his statement has been recorded through WhatsApp since his physical presence before the IO is not possible because it's still in the US in connection with the miscarriage of his daughter since August 2025. learned so and so senior was submitted. Since the applicant has fully cooperated with the investigation of the case when he was not involved in the commission of any offense, prayed that the instant IA may be allowed by dispensing the necessity of him being physically present for recording a statement before the IO. Learned PP submit, though the statement of the applicant recorded through virtual mode and has produced the document. My lord, will please note, showing the status report dated 28/1/2026. He submit perusal of the status report shows the applicant in his statement has denied his involvement in connected with so and so. Learned PP further submits, since the statement applicant has been recorded, physical presence of the applicant before the IO may not be necessary at this stage. On considered submission made by the learned counsel of both parties, it is seen statement of applicant in terms of the court's order dated 10/12/2025 and 19/1/2026 has been recorded by the case as per the status report dated 28/1/2026, which is to be made a part of the file and marked as Annexure X. In view of above, this court finds it appropriate to allow the IA by dispensing with the necessity applicant being physically present for the statement, recording his statement on the issuance of notice under Section 35(3) of
Subsequently, he appeared physically. He appeared.
No, but he was not absent. No, virtual.
What is the present mode?
Virtual.
Still virtual.
Virtual. No. Thereafter, my lord, this was exempted. Now, please.
Permanently virtual.
Yes. Yes. And now, this is by virtue of the court's order, my lord.
No, that's okay.
Yes.
You have not.
Now
has not filed any petition for modification of this.
No. No application modification of the order. Now, my interesting, my lord. Now there is a submission which has been advanced by my learned friend informant or representing informant, and my learned friend PP said that not my learned friend for the informant, but the PP said 94 notice was given, but that was also we have not. He said that it has not been complied. Now I will show 15,000 pages I have sent by courier. I have sent. Now see the order of the court. Not only that, they were harassing from time to time. I have to approach this honorable court. Please see the order of 10/3/2026. This is a virtue of the court's order.
Or the main.
Yes, please see that, my lord. See the order of the court, 10/3/2026.
And 2026.
26.
Okay.
Lordship got it, my lord?
Yes.
Please see the order of 10/3/2026. Now this, kindly see the petitioner heard Mr. So-and-so. See the first, assisted by so-and-so, heard Mr. Zimomi, learned PP and Mrs. So-and learned counsel for respondent number 2. So respondent number 2 by the time has appeared. PP was also present. Petitioner has filed an additional affidavit on 6/3/2020.
So all these submissions are in support of the contention that he has cooperated with them.
Correct. That's what I have answered. No, I have to say.
Let's move on to your reply, main reply.
Yes. 94, my lord, BNSS, my lord, we comply.
Okay, that's fine.
But my learned friend is given impression to the court that I did not cooperate with the investigation.
That's okay.
You have given a notice, I didn't reply. Okay. I replied. I cooperated with them.
Yes.
It is not a case that I have not cooperated.
Fine.
Now they try to mix up the case with those. Now
you think there are the main question in an FIR is that there are no facts and the case of the prosecution on the face of it makes out no case.
Yes. Now my lord.
As we know.
Now, my lord,
very interesting and important decision has been shown by the petitioner side, learned senior counsel. That's very realistic, actually. That in today's times, in most of the cases, it will be, especially in urban settings, it will be difficult to find an FIR, especially, which taken on its face value does not make out. Sometimes it may, but usually it won't. So I do not remember what was the decision.
I will show you.
No, it's there.
No, my lord. What?
That decision is indicated that the other material can also be looked into to see as to whether the FIR may be malicious. That's all.
My lord, Muhammad Ali, that judgment was Muhammad Ali.
I'll look, I remember.
In between the lines. That's what the
Yes,
Supreme
that
Court
can
has said,
be.
in between the lines.
That can.
But what is important, my lord, I have gone again because I have shown the judgment to your lordship. And again, I have gone through the judgment. I rather place that judgment because that judgment is very important.
No, I have gone through it.
Yes, that judgment is
I
important.
only don't remember.
Yes. Now, my lord will kindly. Now, there is also one order of 7/4/2026. They try to mix up with the case, with the other two case. They can't mix up with the other two case. What is my role? Kindly see the order
2026.
7/4/2026. They tried to both the case to be heard together. Kindly see, my lord.
The other criminal petition is filed by whom?
Other two notorious directors of the company. They are the promoters and they are directors, promoter of the company. Lordship got it, my lord? So and so learned can respond.
What is the interim order?
I'm sorry?
Interim order? No
Where?
coercive action.
No,
That means
mine is
no
no,
arrest.
I don't know about the others.
I entered into the picture late, my lord.
Huh?
After all is applica- I entered into the picture late.
Anyway.
I don't know about that case, man. I'm not aware what has happened.
Even in your case, I entered late.
No, I know because notice has gone to you. Thereafter, you appeared in this case. Please see the order of 7/4/2026. Virtue of the court's order, my lord. Objective. So they have raised objection. Clubbing of together is not okay.
That was.
I think in that case, what I have been told, I am not very sure, saying there is no order as such, no coercive measure. Why? Because other two are already on bail. Other two are already on bail. That's why there is no question of passing any order saying that no coercive measure in those two cases.
In some very recent decisions, the Honorable Supreme Court has directed the courts and that when you say no coercive action, specify what do you mean?
Absolutely correct.
Because it's
the Niharika construction.
It becomes very vague. Recently, it has been reiterated.
It's an open-ended direction, my lord.
Yes.
That's a, my lord, but when you see the order which has been passed by this court, by
No,
this
I have
court,
passed like that, but
yes.
Learning from that.
No, my lord, what has happened in Niharika construction, the court said that whenever a status quo order has to be passed, you have to pass a reason order. Why status quo is required?
That is always.
My lord, your lordship, remember, I don't know. There's long back. That circulating at the state, my lord. Status quo order was passed. Then, my lord, lot of people died because a status quo order was passed.
Anyway, so
these are right. So
the law
says.
Niharika is of course a leading case on quashing of FIR. But anyway, so
now my lord is 1 o'clock now. So I think now the question is, I have been told some, my lord, what I can do it. What my lord?
Restrict your submission to the reply.
Yes, I
not further here.
Can I? Because I will not say anything beyond my what my learned friend. What I'll do it, my lord. I'll just, my lord, place
Both of you are, of course, you have given a point. So you are also at liberty to file a written submission if you want.
what I'll do it.
I won't insist, but up to you.
Factually, all points.
No, not you. This will do. This is your written submission. only.
Yes. My lord, because it requires some time, at least 1 2 hours I require, because I have brought certain judgments of this. I know that
I'm telling you, the days of unlimited oral arguments is over.
Yes.
You know, do you know in many countries they've stopped the practice of reading out from judgments? I read recently. You know, so you file a written submissions and restrict your reply to maximum 1 hour. That's all. We don't have time. Other matters are there.
Yes. That's why I will not trouble the court.
As the patient cannot take unlimited time of the doctor. Same. Other patients are there.
But I don't want that, my lord. Also,
No. The times have changed. We are already lagging behind.
Yes,
the world.
I know, my lord.
We are already lagging behind.
Yes.
We have the highest pendency in the world. There are many reasons.
My lord, there
shortage of judges is not the only reason.
But there are cases which, my lord, we are bound to have to show before this court. We don't have any alternative.
You can give
because of the clients.
See, the thing is
because
that most of the jurisdictions now, the parties are being bound to written submissions. Written submissions, you know. Unlimited oral arguments are over. Days of unlimited oral arguments are over. I'm telling you these things. It's a matter of time before we formally have it in India. Anyway, I'm not restricting, but we can resume at 2.
Well,
But
One matter unlisted, I think your lordship has.
I have some matter.
Yes, yes.
But today I can give you only till 3. 3 I have
My
to
lord,
take
can
out.
I do one thing? If your lordship, there are some other matters which I find it also difficult finding. My lord, can it be tomorrow morning? I'll just submit and finish it off half an hour.
No.
Restrict my argument to half an hour.
I will not be here tomorrow, my lord, but my juniors can.
Yes, no problem. You can submit and in between you can send a written argument. That's not the problem.
But please don't take it otherwise that
Why should I?
we are arguing for hours to hours because only because your lordship is right. Because now this change time has come to change it.
Go to other tribunals.
No, we your
so
lordship.
many countries both of you.
That time, but we can't forget about the judgment of the Supreme Court.
That's
my lord.
true.
These are judgment. These are
You know what is the
person life
longest,
and liberty
do you
of
know,
a person is
Do you know what
involved.
is the longest time available for oral arguments in the US Supreme Court, where all the 7, 8 justices who sit together, half an hour, 30
My lord,
minutes.
but my lord, in Belgium it is only 15 minutes.
No,
Belgium.
it may not be
No,
possible.
my
It
lord,
can be extended.
but please see, my lord. Ultimately, last resort is Supreme Court.
See, the thing is, that
But I have not found any of the.
I'll tell you another thing. Think of an exam. Think of an exam, written exam, where there is no time limit. My answers will never be focused. Similarly, if there is no time limit, my arguments will never be focused. When we speak, we tend to repeat. But we do not repeat when we write.
My lord, your lordship,
we have discussed.
My lordship will please remind me if I repeat, my lord. Please remind me. I don't.
No, that's human tendency. When we speak, we always repeat. We always repeat. So anyway, don't worry about that.
Because
So we can. How about taking half an hour after break? I'll leave it to you. I want it.
Because I have to make a note. Is a note will be placed tomorrow, and according half an hour.
Your junior can be there.
My junior BM.
I don't think there will be need for another reply because
Is a reply. My lord, reply is.
I'll be grateful if you finish it within half an hour, maximum say 1 hour.
It will be done.
And in between, you can send your written argument.
Yes.
Yeah, I'll try to dispose of in these few days only. If not, I'll carry the file. And
Gauhati also.
you can send an email to the and written argument. I'll take it out. Don't worry. That's very good actually.
No, now your lordship is right. Nowadays, pointers,
Pointers,
and you argue on point because your lordship is absolutely right. In Supreme Court, 10 minutes, 15 minutes. But your lordship knows, my lord, why your lordship knows there's a highest court. Now, my lord, all particularized high court is the main, my lord. And all the high courts, your lordship is allowing so much of time because this is the last court. Nobody can, my lord, there are clients who cannot afford to go to Supreme Court, my lord.
That's true.
Supreme Court is 15 minutes, 10 minutes. I remember 85, my lord, when we joined, one matters, my lord, it takes 7 days, 8 days. Now it is not possible also. Your lordship is right.
Oh, sometimes big constitutional matters cannot be disposed of in half an hour, obviously. So it will take, but for that special orders to be passed. But generally, it is not done, actually. Just the best analogy is the doctor's analogy. Sometimes serious patient, yes, can be resistant.
Except dentist, my lord.
That is what dentist appointment is very difficult to manage.
Very difficult.
Dentist, we never know what time, how much this procedure
takes about 1 hour.
Because for a consultant, you can always make out first consultation and subsequent consultation. You can make out that. It's very difficult. So anyway, the future belongs to the young boys and girls. So we have to make adjustment, and everyone will be better off. I can assure you these things. I'm also convinced the new systems, more scientific systems, will make everyone better off. There will be more disposal. There will be this things too. Anyway, so I keep it for tomorrow.
Very good.
Okay. Public prosecutor appearing for the state/prosecution submits scanned copy of the case diary and makes his submissions. Mr. A. Jerome, learned counsel for the respondent number 2/informant, also addresses his submissions. He also submits a brief written argument. Written notes in support of his submissions. Mr. Das, the learned senior counsel, addresses his reply, but the same could not be completed due to paucity of time. Leaves the matter tomorrow. Tomorrow, what time shall we take it up?
So can it be taken in the morning half, my lord? If it is not inconvenient to your lordship.
Well, depends on the matters. We can take.
After motion matters are over.
We're flexible. Take it up. Leave the matter tomorrow. The petitioner side is also at liberty to file any written submissions
Yes.
before
Can give a
disposal of the
copy to
matter.
you.
Before
I'll-
disposal of the matter. anytime.
I'll hand over a copy to my learned friend. also.
As a junior, at that time, just not so much, but sometimes you used to make brief points. For junior counsels, one advantage of having a written points is that suppose I'm assisting and my senior is stuck up and the court forces me to. I don't believe in forcing because the interest of the litigant is also there. Or we can always encourage, but not force. But suppose I have to do, although my senior was supposed to do, then that written points comes out great. It's very handy to just put up a reasonably good show. So these are things. How can we just compile this? So tomorrow we'll
Tomorrow,
take,
my lord.
and tomorrow the list should be shorter.
My lord,
in the morning, huh?
morning up, my lord. I will not take then maximum maybe 1 hour 45 minutes. 45 minutes I'll.
So I'll be grateful. I see we don't have that system, so I cannot pass order. But we'll be grateful if it's folded up within 1 hour. I think that should be sufficient.
45
Since you have
minutes?
argued at length.
No, my lord, I have completed my argument. Only I have to rebut and only give a reply to what they are stating, my.
Right.
I cannot say again, my lord,
No issues.
repetition of.
And anything left out, you can submit.
Yes.
Okay.
Okay.
This one will take two. Is not ready. It's still. Or we can take up the other matters till he comes. Or you have a matter. Unlisted. Should we, other councils are there, but we can take it up, the other matters also quickly. Just hold on, Mr. Borgan.
Yes. For admission, item number 8.
Maybe you can finish it quickly. This is the content matter. This is also. Move on. There's no time.
For admission, item number 13.
Yes. Sir.
May it please, my lord. The petitioner here is the accused person, my lord. He seeks release of a mobile phone which was seized from his possession when he was arrested, lordship. And the case of the prosecution in a nutshell is that the accused person had supposedly broken into the Malkhana of the district court Kohima, wherein he has stolen 45 cases of sunflower drugs, lordship, and had sold to unknown persons. My lord, the accused person, he was arrested on 13th of June 2025, and this particular phone in dispute, lordship, this particular phone was purchased 1 day exactly prior to the date of his arrest, my lord. And I've also enclosed a copy of a cash memo which was issued to him. It is at page number 15, my lord. So after the accused person was
page number 15,
my lord, for 15. This is a cash memo issued by N Electronics dated 12/6/2025.
So the owner of the mobile.
Yes, my lord. And may I continue, lordship?
It was rejected by learned trial court.
Lordship, yes. I have approached the trial court on 2 occasions. One, during time of investigation. So that was rejected on the ground that forensic examination was to be conducted. So I have no qualms with that. However, after submission of charge sheet, in spite of the fact that there was absolutely no finding insofar as use of the phone was concerned, the IO has made no finding whatsoever. However, in spite of that, the learned principal and the district judge was of the view that it would cause prejudice to the case of the prosecution, quote unquote, my lord. So during the time when I had approached the trial court, the learned PP had argued on the line that it was from proceeds of crime, lordship. So I am aggrieved with this order for the reason that when the charge sheet was bereft of any finding insofar as the use of this particular phone is concerned, my lord, it could not have been presumed that this was from proceeds of crime because there was no facts and figures, no findings as to who it was, the drugs were purportedly sold to, when it was sold, how much it was sold for, how much money was purportedly made by the petitioner when all these drugs were sold. So in the absence of such findings, my lord, it cannot be presumed that this property was purchased from proceeds of crime. If at all this logic was to be made applicable, then any property of accused person having substantial value, be it jewelry, a TV, car, immovable property, fridge, anything can be seized, my lord. So that is my case, my lord. Data has already been analyzed, and so even otherwise charge sheet is filed.
I get it.
Lordship.
So charge sheet has already been filed.
Yes, lordship. It is fixed for evidence.
Make your submission.
Lordship, as far as since on the last occasion, 4/6/2026, lordship, LCR has called for lordship.
SCR is received.
Lordship.
Notice.
Lordship, I'm told it's here. I'm told TCR, yes, lordship.
It's there. So we have to just see whether, first we have to see whether it is a relied upon document. If it is not a relied upon document in the since charge sheet has been submitted.
Lordship,
If
yes.
it's not a relied upon document, then it is a very good case to give it back.
Lordship.
If it's not at all relied upon.
Lordship.
If it is a relied upon document, then probably, because if electronic as you know, if the electronic document is relied upon as a material object, it is sealed and all stepped and all that. So if that has to be given back, then you have to see whether the extracts, etc., as you said, has to be taken out. Otherwise, once that is removed And then it may cause some difficulties for the prosecution. So only these two things we have to see.
Lordship, I submit with greatest of responsibility. I've gone through the charge sheet. There is no
Nothing.
Yes, nothing, Lordship. There's nothing.
Charge sheet is
As
here
best it
also.
says that
You
the
have
phone
the,
was.
you have the charge sheet?
Yes, I've enclosed it. It
Kindly have
is
it.
at page.
I have
Lordship,
this. Because
It is part of my petition. Lordship.
Kindly have it. It's, I'll look from the.
It starts from para 20, page 26, my lord, the charge sheet.
I mean, we'll not go into that. The only aspect of the whether it is necessary or not. But it's, I mean, the offense is also, breaking into a microfinance, stealing that to drugs and selling it. Anyway, that's a matter of trial. That's a matter of trial. It's presumed to be innocent. There's a form in the charge sheet. There's always a form. The documents relied upon.
Yes,
the properties.
Yes, Lordship.
Details of properties. Which are the documents?
Lordship, it is
which are
at page
relied upon.
29. Page 29, my lord.
So we can see from that.
At the time of the Zima hearing, there was an averment made that it was sent for forensic examination. However, no reliance is placed on that. So I believe the IO could not find anything. Therefore, he has not relied on such findings in the forensic lab.
Pretty clear from here. Otherwise, you will have to take an instruction from the IO. Lordship, I have to take it. If it's not clear, it's not clear. But it is he's not following the format. There's a specific form. There's a column for that in a table. Yes. The materials relied upon. Caesar is different. Caesar was at a stage. All seized items may not be necessary. But if that mobile phone is an important material of evidence, then it can be. In that case, there may be some difficulty. Till it is exhibited. Once it is exhibited, it can. So, can you take the instruction?
Lordship.
Otherwise,
Nothing has been
feeling little handicapped. Apparently, it's not there.
Lordship, for what it's worth, there's absolutely no finding. So the question of examining it physically, because the data has already been extracted. Anyway, Lordship.
So, can you take the instruction?
Lordship.
Day after tomorrow?
Yes, Lordship. 18, I have another matter.
Day after tomorrow, but division bench is there.
Long list. My lord, can accommodate me on 18th?
Yes, on Thursday.
Yes, please.
Third, short. Landed public prosecutor for the state. The petitioner is agreed by order dated 26/3/2026. Passed by the learned trial court in GR number 24 of 2025, arising out of Kohima 16 of 2025, whereby the prayer of the petitioner for interim custody of his mobile phone was rejected. The case has already been charge sheeted and presently poised for trial.
Lordship.
Poised for trial, full stop. Scan copy is received, full stop. However, from the materials, is not very clear as to whether it's not crystal clear as to whether the mobile handset in question is one of the relied upon material objects for the prosecution case for the trial. Therefore, in this context, the learned PP shall take an instruction from the concerned investigating officer and make his submission for the court. It is also open to the prosecution to submit a report on the matter. Lodge. It will be better if you list the matter on 18th.
Lodge.
For orders, item number 26.
My lord, I beg to appear for the petitioner here.
Just a minute.
Hello, may I please? Hello, my junior is carrying a list of written notes. In the list of dates, relevant list of dates, Your Lordship, may that be handed over? I think that will be ideally, I'll be placing from that document, Your Lordship.
List of dates.
List of dates, Your Lordship, because I think it's ideally the PP on last date was submitting regarding the conduct of the petitioner. So I think that may be placed, Your Lordship. So what we have done and what has transpired, Your Lordship, the list of dates may be give a fair idea to Your Lordship about what has happened, Your Lordship. Lordship has taken up the document, Your Lordship.
I have your document.
Lordship may kindly come on the third page, Your Lordship, of the document. Lordship, on 16th of February, a FIR was registered, Your Lordship. And subsequent date, Lordship, on 16th of March, Lordship, I, through my advocate, because prior to that, I had no knowledge about FIR. When I came to when I was aware of the FIR, I personally sent a letter to an investigating agency seeking a 35 fee notice, Your Lordship, on 16th of March. Subsequent to that, Your Lordship, on 17th of March, I received a communication from the police authorities, Your Lordship, stating that they were not able to serve upon me, and that is there, Your Lordship, in the main application, page number 99, Your Lordship, annexure P7, and there it contains that I was not being found, and they did not have any communication with me earlier. Subsequent to that, I replied, Your Lordship, on 20th of March, seeking a correspondent details. On 25th of March, Your Lordship, details were provided, and on 28th of March, which is in my annexure P8, a 35 fee notice was issued to me, Your Lordship. That was the first 35 fee notice that I received, Your Lordship. And that was on through mail, Your Lordship.
Okay. On 4th.
On 28th of March, that was the first notice that I received, Your Lordship. Subsequent to that, Your Lordship, on 4th of April, I requested a letter was sent from my end, Your Lordship, that the physical notice be sent to my address. And on 4th of May, Your Lordship, this application was first heard. This instant revisional application was first heard, and an interim protection was granted to me, Your Lordship. This was admitted, and interim protection was granted to me. Thereafter, Your Lordship, on 6th of May, because on the first order, there was a liberty given to the petitioner that he can appear virtually. So a letter was sent to the investigating agency on 6th of March, Your Lordship. On 11th of May, it was further heard, and the last order, Lordship may kindly seize, on 11th of May, I was directed that for learned PP, with greatest respect, he submitted that certain documents needs to be physically verified. So I went there, Your Lordship, and I was directed by the Honorable Court that I may appear physically on a coordinated way. And interim protection was extended till 12th of this month, Your Lordship. Thereafter, Your Lordship, subsequent communications happened. And on 22nd of May, I issued a letter seeking my response to appear and decide on a date, Your Lordship. And
okay.
And thereafter, Your Lordship, subsequently 5th of May, the 5th of June, a date was fixed. It was dated by the investigating agency on 20th of May. That letter was issued to me. The Lordship may kindly take up annex, no? So, Lordship, I don't know whether it is being given to Your Lordship or not, but I'm just placing from the document that I have that the notice that was given to me. Accordingly, you are hereby directed to appear before the investigating officer at 1100 hours at 5th of June at the State Crime Police Station without fail. It was subsequently directed, Your Lordship, you are further directed to remain stationed at Kohima and make yourself available for investigation purposes till 8th of June or until further direction from the investigating officer, whichever is earlier, Your Lordship. So, Lordship, my compliance for one day, that is for 5th of June, I was being directed by the investigating officer to be stationed at Kohima till 8th of June. 5, 6, 7, 8. 3 days I was being directed to be stationed, Your Lordship, for the purpose of investigation. Now, the petitioner again sent a representation to the investigating agency subsequent to that, Your Lordship, stating that he was unable to stay and this was not the purpose. So, Lordship knows we have it was stated there that 35(3) notice did not contain direct to be stationed for a personal liberty to be curtailed, and the direction was there by the Honorable Court that person cannot be interim protection was extended to me. So, subsequent to that, further, this direction was retracted. This direction was retracted, and I was told to come and on 5th of June. Now, Lordship, here what my